there is a lot of misgivings, misunderstanding of what NIC stands for, what the jurisprudence is all about. Today, we hope to clarify some of these misgivings, both from our end and from the end of the bar. With this said, I welcome you to today's session. What we have tried to do within us is to try as much as possible to streamline. It will not be just me talking. Some of my colleagues will also be talking depending on the questions that are asked. So it's not so much the president of the NIC talking. Of course, there are some questions that will boil down on this relating to the court. If they do arise, I will address those issues. But generally speaking, the questions I saw are more as to the quality of the jurisprudence. Not many have asked anything about administration or anything of the sort, but it all depends. And I'm thinking that particularly one question can generate more questions. So depending on how it goes, we are ready to interface with the bar today. Feel free, like I said, to comment and ask questions as freely as you can think. But please remember, let's be decent in our language. Thank you.
My lords, the president of the National Industrial Court of Nigeria, my lord Honorable Justice Bibikaye, the august visitor, the courts, and by extension, practitioners before the courts, my lord, the president of the Industrial Court of the Trinidad and Tobago, I honor my lord, Mrs. Deborah Thomas Felix, my lords, judges of the National Industrial Court, senior colleagues in the NABA, Mr. Roland Otaro SAN, the chairman of the Employment and Industrial Relations section of the committee of the section on business law of the Nigerian Bar Association, Mr. Osei Okweku, my colleagues, the outer bar, distinguished ladies and gentlemen. For us, it's an honor and indeed a privilege to stand before you today to welcome each and everyone to the Bar and Bench Forum, jointly organized by the courts. Although my lord, the president, likes to say it's our show, we will run it. And I like the assurance given in the welcome address of my lord that it's really a no holds barred session, as long as done within decent language. And when my lord said that, what I did was to look back and just to be reassured that we don't have the police audits around. There's nobody to hold us to. And then I said I would. Well, I mean, that gives some reassuring confidence that indeed we can engage the court. And engaging the court is all about wanting to know, as practitioners before the court, to understand what we need to know to start with. Let us understand what we need to know every time we come to plead our client causes before the courts. We do not take for granted that, well, I mean, what we've been taught or what we think is the position of the law remains the position of the law, especially when you're faced with a progressively evolving labor law jurisprudence that the court continues to teach out, and understandably within the context of the establishment law of the courts and Section 254 of the Third Authorization. I think I'll just keep it for now. Welcome everyone. My name is Falabi Kuti, and I will be standing here with my colleague. Mary, let me introduce you. The lovely, beautiful Mary Kemeze will both be running the show as to use my Lord's support.
Thank you for that. Thank you. Okay. And so it's my honor and privilege to ask for the goodwill message by the President, Industrial Court, Trinidad and Tobago, Her Honor, Mrs. Deborah Chalmers Felix. Your Honor.
Thank you. Good morning, everyone. Special good morning to the President of the National Industrial Court of Nigeria, judges of the court, and members of your inner bar. Apart from the fact that I do wish you very well in your new year, I think it is very important for courts to invest in resources to train and educate judges, and also to engage the bar and stakeholders and users of the court. Now, yesterday, I made mention to a program which I started in 2013, and it is singularly the flagship program of the Industrial Court of Trinidad and Tobago, where we have chambers of commerce, business, trade unions, governments, senior lawyers, because mainly senior lawyers practice in my court, not really the junior lawyers. And what we do is that I bring one of the lecturers in labor law from the University of the West Indies, Barbados. I bring one from Jamaica. I have somebody from the ILO, and I will always have an expert in the economy who is an expert in economics. What you will find is that there is no way you can be engaged in industrial relations without having a sense of what is going on the external, meaning the economy, and what is going on in terms of the labor market. Within the industrial court, we have a research department under the laws of Trinidad and Tobago. And that research department is housed with economists, statisticians, and all of that. When we have matters in court, parties will ask for a research note, maybe on a sector, maybe on a particular type of job, and we will adjourn to get these research notes which guide us. One of the things I did is to engage who is now the governor of the central bank, but he was not governor at the time, he was a deputy governor, to work with my research department, see where the pitfalls are in order to improve the quality of work which they produce. And I sent members of staff to be trained in the US on productivity, so that when I have my annual report and I'm reporting about the work of the court, the empirical data is extremely important. So I don't know about the purse of the court. What I am saying is, in that purse of the court, consideration ought to be given to the education of judges, especially in current trends, and also the meeting together, like in this forum, of all practitioners. But in my case, I didn't want judges to be defending themselves. So I will bring neutral people who will train and you ask questions, but I can be very much of a dictator, like I told the judges. So I do not allow people to come and use mics and ask questions, because my trade union say to me, President, if you give me a mic, I'm not putting it down, because the question goes on and I want to make this point. So what I do is I set up I take a hotel very large hotel, and I have a bowl, and I let you write your question and drop in the bowl, and my staff goes, picks up questions throughout the entire thing, and I have 4 members of staff typing it up on a screen, and whoever is the moderator will read the question, and that saves time. Because lawyers love to talk, trade unionists love to talk, and business people love to plug. Either way, it makes time run. So I think this is an excellent initiative for the bench and the bar to come together. I do not think that the bench, like I saw yesterday, should sit as court of appeal for the judgments of the court. When the court has rendered its judgment, the court has rendered its judgment. And we as judges know that when you do a judgment, you're right. When it goes to the Court of Appeal is right. When it goes to the Supreme Court is right. So with that in mind, I think the time should be spent on analyzing instead of criticizing. That's what I want to see. And I wish you all the best. Thanks. Yeah.
Thank you very much, Your Honor. I should mention that we have quite a number of our colleagues joining us online as we're aware this is a hybrid event and we have well over 100 persons. Thank you all for your patience, particularly since you've been online for a while before we started. We'll have the address by the chairman of the MBA-SBL, Dr. Adeoye Adefulu. He's going to address us next. Yes, he's going to address us virtually, yes. And after he does come on, the chair of the SBL ERIC, Mr. Osakweku, will speak to us. So Dr. Adeoye, we'll give him a few minutes to put on his video and we'll take him. While this is going on, a few housekeeping. We're passing papers around. We already have collated questions from our colleagues before coming here. We know some persons are typing their questions online and there is a group working on collating those questions. But for those of us who are here in person, if you do have any questions, there are papers available. If you don't have any, you could signify. My colleague Max will send the paper across so you can put your question down. Dr. Adeoye, are you online now?
I am. I'm not sure. I hope you can hear me. Can you hear me? Mary, if you can hear me, please respond, or anyone else.
Dr. Adefulu, we can't hear you. Do you want to mute yourself, please?
I am not on mute. Okay. So everybody online says they can hear me. I hope the people in the hall
hear you.
Excellent. Okay. So let me the protocols.
Okay.
My Lord, the Honorable.
We can't read your lips. So let's ask that if you can hear us, we cannot read your lips. No fault of yours. We're trying to rectify. Louis. Sure. Louis is unmuted.
I am unmuted.
Dr. Adeoye, if you could hold on a bit, there's a bit of a technical hitch from our end, and they're trying to resolve it so that we can hear you because we cannot hear you from here. Thank you.
Okay.
In the meantime,
that's
so
fine.
In the meantime, while we're waiting for that to be resolved, we're going to ask Mr. Osakweku, the chairman of the SBL EIRC to address us. Thank you.
We can hear him, please.
Good morning, everyone. First of all, I would like to once again apologize that we are starting slightly behind schedule. And I thank you for your patience and the time you've spent, especially for those that have been online for a while now. I plead to stand on existing protocols. However, I must acknowledge the presence of my Lord, Justice Kayi, PhD, who, apart from being a friend, is one of my mentors. And I thank him for the time he spends with me, take time to answer my questions and to also direct me in the right path. I'm very grateful, Milord. Again, it is always difficult to have to speak after Milord has spoken on this, because as we all know, he would have said everything. And so it's always a hard act to follow. Okay, thank you. I will do try though. Again, my case has been made worse by the fact that I have to speak also after my Lord, the President of the Labour Court of Trinidad and Tobago. And she's rightfully referred to as a brain box for someone who has written 2 labor law books in 2 years. And in 1990, she was elevated to the bench as the youngest lawyer to be elevated to the bench in Trinidad and Tobago. So you understand when I say it's a big task for me to speak after these 2 very illustrious persons. However, it would have even been worse if the chairman of the SBM had spoken before me. But thankfully, I'm from Edo State, so I've used my witchcraft powers to make it impossible for him to speak. So I will have time to speak. So do you understand why there's a technical fault? Ask my Bini brothers. I mean, but the law does not recognize witchcraft anyway, so I'm free. I'm not a comedian. If I were, I'll probably tell a joke. But I will tell 2 very important stories. One from a professional point of view and one from a personal point. So in 2011 or thereabout, a client was going through restructuring and invited myself and my firm as the employment and human resources, strategic human resources consultant, and invited a certain lady who then was the HR director of a bank as a co-strategic HR consultant. It turns out that, I mean, I won't name names, but it turns out that the MD of the company was not happy working with the PA and wanted the PA sacked. Problem is, this PA was on maternity leave and she's been gone for a month. To my greatest shock, the HR director turned around and said, "Of course, I'll terminate her right now and now." I'm like, how is that going to happen? I said, "No, don't even go there. We do that in the bank every day." So I said to them, how can you possibly terminate someone who is on maternity leave? Section 54 of the Labour Act is very clear on what needs to be done. And they said, "No, we're going on with this." And I said, "Well, you know what? I mustn't do this job, but I'll give you a legal opinion. If you want to go by it, fine. If you don't want, you're fine." Thankfully, a member of the board who today is a learned senior, was a learned senior advocate then, and today is an OFR, said to them, "You've invited this man here because of his competency. This is his specialty. If you not listen to him, what was the point? I'm a senior advocate. I don't play in this space. So I will accede to his superior argument in this area. So please listen to him." And thankfully, they listened to superior argument and the lady was not terminated. But I do know that after a couple of months, when she returned, she was let go. The second story It's slightly personal. So I try at least, once in a weekend to have lunch with my family. So one of these Sundays, I have two daughters and a son, and we're having lunch. So my first daughter was eating and then decided to eat her meat first. And my wife turns to her, "Adiswa, why are you eating your meat?" And my daughter looks at her. But it took her time, finished her meat in her mouth, looked at my wife and said, "Oh, Mama, it's my meat. Why can't I eat it when I want to eat it?" My wife said to me, "Do you hear what I just said? Answer her." I mean, so for a man that has a daughter as the first child, and you have a wife, so you are in love with your wife, your daughter is in love with you, so you have to find a way to strike a balance. And, I smiled, the best smile I could actually muster, and said to her, "Sweetheart, I think you should answer her, but don't you think perhaps we should have this conversation later?" And then she listened. And it occurred to me when we got upstairs. I said to my wife, I mean, if you were born in the 70s and the 80s, it was a crime to eat your meat before you eat your food. You would not dare do that. But I thought our parents were trying to teach us delayed gratification. And it suddenly occurred to me that it worked then because we are a generation that we are taught to listen and obey and not to question things. For this generation, they call this Sorosuke generation. They will ask questions. And so what this story brought to mind is the fact that we are still trying to deal with new issues with old solutions. And also, a lot of us are stuck in a time warp and we don't want to move out from common law principles and master-servant relationship principles. And that is the situation we have with our employment law jurisprudence at the moment. Luckily, there are some of us that have embraced the new order and understand clearly that the jurisprudence has long moved. But some of us, practitioners, HR practitioners, lawyers, still are stuck in that time warp to think that I can hire and fire for any reason or no reason at all. That someone can be on maternity leave and can be terminated. That the worker has no rights. It is a very worrying scenario. And that for me was just a bit of a background as to how we got to where we are. So having experienced this, just to give a bit of history as to how we got to where we are today. I recall in 2012, my partner then, Tony Woche, myself, and Chuka Ekwazom, SAN, met with Aswa Ighodalo and Udo, who then were as part of the Excludes of the SBL, and said, the employment jurisprudence in Nigeria is suffering. We have a committee that's moribund. Can we revive this committee? And he said, go ahead. So we started with consistent meetings and some trainings. But I recall in 2014, we had our first holders forum and we invited my lord here, Justice Kai, to come and address us. And a lot of people in that hall that they were shocked with what he had to say because the employment jurisprudence then had so moved on. A lot of people were still stuck in asking questions as to name on the contract and all that. And Justice Amadi was also there with us on that day. So we kept moving. And by 2018, we organized our first national conference, which again, Justice Kaib delivered the lead paper. And on that day, the theme was labor law, employment law, the changing landscape. Because we realized the landscape had changed. By 2019, we had our second national conference. Unfortunately, Milord could not come, but Justice Obaseki gave the lead paper on that day, and that was themed employment law, managing the current realities, because we knew that the realities were totally different. And so that's how we got to where we are. I mean, because of the pandemic, we are unable to hold any conference between 2020 and 2021. But this year, our conference, hopefully, we hold in December in Abuja, and we're grateful if everybody would make time to attend. We decided on a 3-point strategy, which was based on education, impact, and influence. As part of our education and impact, during the pandemic, we partnered with Business Day to deliver a series of webinars tagged Digital Conversations. And some of those justices present today participated as panelists at those seminars or webinars. We brought to the fore issues around remote working, compulsory vaccination, safety in the workplace, sexual harassment, and mental health. At some point, we also realized that there is a fundamental problem with our university curriculum. We realized that a lot of interns coming to our offices were still being taught labor law prior to the third alteration. And so we started a new initiative, which was to bring students from the universities to the National Industrial Court to meet with the judges so they could see what it's really like. Unfortunately, we couldn't continue with that because of the pandemic, but we hope that by this next year, we will resume that initiative. For me, it is really worrying when HR practitioners generally miss the point in the new reality of employment. But for me, more worrying is when our lawyers actually strenuously argue that the common law is still the ground norm for employment law in Nigeria. It is very, very worrying. We will continue to educate, but we will now seek to influence the employment law space. So as a committee, we will henceforth be on the menu or be sitting on the table because this is the only way we can actually influence policy. We will still continue to educate, we will still continue to impact, but we believe that we need to start influencing policy. It's also a huge worry that despite the enormous powers of the Minister of Labor under Section 18 of the Labor Act, very few regulations have been made to deal with emerging issues in the workplace. Funnily, it's actually the Minister of Petroleum that seems to have taken some form of initiative in this area. My Lord Justice Kanip, I'm sure we have one or two things to say about that with this decision. A couple of days back, the FG ratified Convention 190 on violence and harassment in the workplace. I'm sure my Lord Justice Obasaki will say we'll have one or two things to say about that as well. So we're looking forward to that. I'm happy to report, Joe, that prior to the NBA, prior to the ratification, the NBA, through its Women's Forum, had come up with the sexual harassment policy following the damning report by the IBA on the scourge of sexual harassment in the legal profession. Just to mention that this was a result of the breakout session organized by our committee at the 2019 SBL conference. The breakout section tagged Me Too, sexual harassment in the workplace. And Justice Obasaki Osage was also a panelist on that section. And after that session, the NBA decided that it was about time they had a policy because of the stories that emanated from that session that day. So part of the influence and impact we have made also is that I was part of the committee that designed the framework and guiding principles for the implementation of the FBL sexual harassment policy, which was presented at the last AGC and has now been adopted by the NBA. I think we should give the NBA a round of applause for actually adopting that policy. As a committee, I dare say that one of the most important initiatives is this bar and bench forum. Just to follow up on what the PG of Trinidad and Tobago said, let me emphasize that it is very important that we have open, frank, and engaging conversation. We must not personalize this, and it must not be an opportunity to use undecent language. I think if we do that, we will lose the moment. Because thankfully, I was going to ask the law that this becomes part of the legal calendar every year, but he has mentioned that, so no need to mention that. But if we do not engage in constructive conversation, we stand the risk of losing this opportunity. So I'll please ask that we are mindful of the comments we make and to keep it to issues and not personalities. Finally, when we set out some 12 years ago, 10 years ago, and please forgive my French, part of our plan was to make employment law sexy. Because a lot of people came around, oh, I'm a tax lawyer, I'm an energy lawyer, I'm this lawyer. Nobody wanted to be known as an employment lawyer for some reason. So we said, this can't be right, because it's either you're an employee or you're an employer, and you know someone who is an employee or you know someone who's an employer. And as lawyers, we advise employers of labor as well. So really, everyone should actually understand the basic principles of employment law. And we thought it was very important that we have people who are key opinion leaders that people will look up to and say, oh, these are employment lawyers. And I think to a large extent we have succeeded. So we have a member of our ranks on the senior advocate list, Falabi Kuti, and hopefully this year we'll have another person. And I'm happy to be known as an employment lawyer. I don't know about you, but I am happy to be known as an employment lawyer. So all this would not have been possible without the team that we're working with for past years. I'd just like to say thank you to the past executives, Tony Nguche, Chupa Ekwazom, to Ifoma Ota, Olabikuti, Mary Kemeze, Jamil, Uguna, Natalia, Benga, Benita, Jibiko Shodi, and the rest of the members of the committee. I can't thank you enough. My Lord and his brothers, I must put it on record that the kind of support we received from the Lord and his brothers have been amazing. We've never invited them for any function and they failed to turn up. They've always given it their all, and we're very, very grateful. We hope that this cooperation and support continues, because we truly need the National Industrial Court to continue pushing the boundaries with its forward thinking and positive proactiveness. I mean, I can't forget Professor Agomo. Unfortunately, she couldn't make it here, but she is one person that's given us enormous support as well. Prof, if you're listening to us, we're very, very grateful. What is really refreshing for me is the number of young people who have taken interest in our committee and participate actively. And it then means that there are people who are positive thinking and ready to take the committee forward when we take our exit. So I'm very grateful for that as well. And just to say thank you to some of our senior colleagues who came all the way from Lagos, Chiofilo Semua from Alex, I'm very grateful. Thank you for the time. And our sister from Ghana, Ekwa Hafron Benjamin, she was here yesterday and she's on her way here today. Perhaps you're able to share some insights from what happens in Ghana, so we can compare notes with Ghana, Trinidad and Tobago, and Nigeria. And perhaps there are some things to learn from that. Thank you very much, and I look forward to a very engaging session.
Thank you, Ose. As always, it's a pleasure to listen to you. We have now resolved our technical issues, so we'll invite the chairman of the NBA SBL, Dr. Adeoye Adefulu, to address us now. Dr. Adefulu.
Hello, Mary. Can you hear me? Can you confirm? I'm not sure you resolved the technical issues.
While we're waiting for him to come on, just to reiterate again that you can send in your questions by writing them down. And if you're online, you can send your questions on the chat box online.
Hello, Mary, can you hear me?
Dr. Adefulu is here now. Thank you.
We can
Can you
hear
hear me?
you. We can hear you.
Okay, thank you very much. Let me start with the protocols. My Lord, you can't hear me.
If you can't hear him, please your system is having issues. We can
I
hear
think
you.
everybody
The broomstick
online
was
can
a
hear me.
prophet, was a powerful. Even after he's left.
We
Dr.
can hear
Adefulu,
you.
you need to
We can
appease
hear you.
Jose.
I am. Everybody online can hear me, but unfortunately, you can't
fantastic.
hear me.
Jose has given the nod. Dr. Adefulu, you can speak now.
We
Can
can
you hear
hear
me
you.
now?
We can hear you, please.
Okay, so let me go ahead. Let me go ahead. My Lord, the Honorable, the President of the National Industrial Court, Honorable Justice Bibi Kani, PhD. Let me also acknowledge the president of the Industrial Court of Trinidad and Tobago, Mrs. Deborah Thomas Felix. I it's a special honor to welcome you to Nigeria. I have had the privilege of traveling to your beautiful country. I also have two sisters-in-law who are from Trinidad, so I'm very closely affiliated with your country. Welcome to Nigeria. My lords, the judges of the National Industrial Court of Nigeria, senior advocates of Nigeria, the chair, he has self-stated that he's a wizard. Mr. Okweku, the exco of the Employment, Labor and Industrial Relations Committee, members of Nigerian Bar Association, Section on Business Law, ladies and gentlemen, good morning. I would like to thank you for the opportunity to say a few words. And just like Ose, it is very difficult to say a few words after the illustrious speakers that have spoken ahead of me. Unlike Ose, I am not an employment lawyer. I work in the energy space, but I'm very excited about what is happening in the employment law space. I am not surprised that the NICN has taken the bold step to have this kind of engagement. I think it is in keeping with the values and the ethos of the NICN since its founding, and certainly since President Kanye was made the head of the organization. I think it's also natural that you have found a collaborator in the NBA-SBL, and particularly the EIRC committee, who have done a lot to promote the employment and industrial relations in Nigeria, employment and industrial relations law in Nigeria. I am very enthusiastic about a forum like this, the opportunity for us to engage with the judges. And as the Honorable has mentioned, it is not a forum to criticize, but a forum to analyze and to make things better for the future. So I am commending this forum to you, and I would like to enjoin us all to debate and discuss the issues in the spirit and in the environment which Honorable Justice Kanye has laid out for us. We also, the chairman has mentioned that our focus on the ABA-SBL is impact and influence. And I think in many ways, this forum allows us to achieve both those objectives. Impact in the sense that people learn, people are educated about the way in which the National Industrial Court works, perhaps even the reasoning behind the decisions of the judges of the National Industrial Court, and influence in the way that we ourselves as practitioners, as educators, can seek to lend a voice to shape, I wouldn't say shape the decisions of the judges, but at least to give some kind of environmental background that might put context into the discussions and into the decisions ultimately. I would also like to say that in the area of labor law and the labor legislation in Nigeria, which, as Ose has mentioned, very few regulations have been issued. And there are a number of issues that are arising, the context, the world in which we live in, since the Labour Act was established has changed significantly. Therefore, there needs to be some advocacy in ensuring that the legislation actually reflects this new working environment. And so I'm hoping that as a part of this discussion, elements of improvements to jurisprudence, elements of improvements to our legislation and to our legislation will be discussed. So thank you once again. I welcome you and I wish us all a successful deliberation. Thank you very much.
Thank you, Dr. Ade. Thank you very much. We're now moving right into the main event for today. These are the questions that we have for our Lord. Mr. Kutsan will go fast.
All right. Very good morning again, everyone. I mean, well ahead of today, we collated and asked colleagues to send in questions or comments, various things that they would like the court to address at this session. So in all, we have some questions numbering up to 26, and then hopefully we intend to take all of them today. And then my Lord, the president of Trinidad and Tobago's Industrial Court, at some point, my Lord, will be calling on my Lord to also, perhaps if possible, give us comparative analysis to drop from, especially responses that we're able to elicit from some of the questions. So at some point, we'll probably be asking my Lord to also intervene. And so from the questions, we'll be asking the questions, and then my Lord, we would be expecting the answers. Thankfully, this is probably the only time we can get to stand before my Lord and ask my Lord questions, and then not be cited for content. And then we want to make the best use of it. And it's so good to stand before my Lord and then be posing the questions. Unlike when you appear before my Lord and maybe there's an area that you seem to be struggling with in the advocacy, and my Lord said, have you considered this? And then you must answer, even when you don't have an answer. But today we would ask for the questions. And the last time I checked, I think we have over 137 persons online, and they've been sending in the questions. They've been firing the questions, and then we are going to load those questions in addition to the 26 that we have. So it looks like we have a long day ahead today, Mary. Yes. Very interesting one. If it's once in a year, we should be happy to have it. If it's going to be more than 24. So the very first question, my Lord, it's something to do with understandably, to do with procedure. Some of our colleagues, in fact, I remember that almost about 3 persons asked this particular question, and then we had to marry the questions into one, to produce one. And the concern is actually about the practice direction issued by this court, by the National Industrial Court, under the hand of the president some time ago. This is the 2022 practice direction, specifically to look into, I recall, 2 major things. Matters dealing with trade unions, the need to file within particular jurisdiction, and the reasons sufficiently provided, as well as, and that is really where the question is, and I'll read the question. The new NICN Practice Directions 2022 mandatorily prescribe striking out of an action for non-compliance with such stipulation as to marking of documents or identifying the documentary exhibit to be relied upon. So the practice direction says that if you file an action and then it is not properly marked, the document to be relied upon should be properly marked, and then the exhibit is not properly marked. But that if they are not done, the penalty would be striking out of that action. So the question has been asked, is this not contradictory to the intent of both the Evidence Act and even Section 12 of the NICN Act on departure from the provisions of the Evidence Act in the overriding interest of justice in deserving cases? That's question number one. I mean, it's a twin-pronged question, heavily loaded. The following, there's also a question or a concern, if I can put it that way, that the wording of the practice direction also introduces in some parts, specifically paragraph 3 of the practice direction, that from the date of this practice direction and notwithstanding any provisions in the National Industrial Court Act, Civil Procedure Rules 2017, notwithstanding any provision, almost like the hoping of Section 254 of the Constitution now, that notwithstanding whatever is provided elsewhere in this Constitution, the NICN shall have this. Now, the question has been asked with reference to the highlighted portion, that is the provision in the NICN rules. Allow the president to ask the question that allow will give us an indication of
There's no problem. Just a quick answer. Let's start from the premise of the rules themselves. If you look at the rules carefully, there's a provision, I can't remember exactly, which allows the judge even to suspend all the rules and adopt something different in the interest of justice. So if the rules themselves have a provision that says you can suspend everything in the rules and use something else, I really don't see how contradictory the practice directions are. Secondly, the question of striking out relates to only when the claimant is deficient. And we use the word striking out deliberately, just so as to emphasize the point that he still has the right to refile, subject, of course, to now fulfilling the conditions. And why we made the rule the way it is because of judicial decisions that exist that says where, and we have a similar provision even in our rules, which says that in filing, if there are some things you don't do, the registry is allowed not to accept processes. Court of Appeal has interpreted that provision to mean that if the registry accepts the processes in error, the court is mandated to hear the case. And we don't want that outcome. We believe that thereby the actions of a registry compels a court to act. It's almost like the scenario in the Constitution which says, if you're looking for leave to appeal, you start with the High Court. If the High Court grants you leave, automatically the Court of Appeal or the Appellate Court in issue must take. I, for one, believe that in circumstances like that, a lower court is now given statutory or even constitutional authority to bind a higher court. Logically and jurisprudentially, I think is wrong. So for me, the actions of a registry should not bind a court. Because if the registry accepts, almost invariably, if a process is brought, registries hardly turn back those processes. So when they accept, they compel the court to hear. Now remember, we are doing this to save time. And in saving time, we think that if you are not ready to come to court, if you are not ready to do what the practice directions say you should do, then go back and get ready. The idea about striking it out is that go back, do the correct thing, and do. I agree there's a complication now with recent Court of Appeal decisions regarding the applicability of station law. And that's why in my speech I said, let's allow it work a bit and let's monitor. When we see how effective or how some of the provisions have problems, of course, we'll take a second look and look at it. I know that there's a danger now with the recent Court of Appeals, which came after the practice directions, where they now held that limitation law applies to employment matters. This is going to pose a problem. But of course, the expectation on the part of counsel is that first and foremost, make sure you do the correct thing. If in the workings of the practice directions, we discover that striking out cases will amount to cases being statute barred, naturally we would look into it and allow for a leverage that does not support striking out. But like I pointed out at the legal year speech, we need to walk the practice directions first and then see how it works. But the key thing, and I'm sure lawyers will understand, is that the advantage of the practice directives, which I pointed out even in my speech, is that it helps us to do away with the rule that says judges are not investigators, they are adjudicators. Because I have seen several cases, and indeed my colleagues too have seen several, where documents are cited without reference to particular areas supporting actions. It's not the job of the judge to start going through the marsh of documents, sometimes running into thousands of pages, just because we are looking for something that is applicable to a particular case. Like I like to tell lawyers in court, don't expect the judge to do your work. You are the one who is earning a fee. Please earn it.
My Lord, thank you, my Lord. We thank your Lordship for providing insights as to the rationale behind that practice direction. Just to add, please, my Lord has said that we can always ask follow-up questions from even the responses got. So I'll take it that we are okay online as well. I don't know if there's any comments coming from my Lord's explanation as to the practice direction. We can go to the next question.
Thank you very much, my Lord, for that very clear insight as to why we have this new rule. The second question we have is in relation to non-compete clauses. So there have been contradicting decisions from the court with respect to restraint of trade contracts. Now, against the backdrop of the Federal Competition and Consumer Protection Act, which allows for non-competes for up to 2 years, what should lawyers who are advising on non-compete provisions in employment contracts look out for in order to ensure that the clause is enforceable, even now that we have a law that says you can have this for up to 2 years? And then what is the measure of compensation for wrongful and unlawful termination? As we've seen different measures applied in different cases, can we have some form of guide?
Maybe I should just remain here. The rule when it comes to contracts and restraint of trade is that first and foremost, it's unenforceable, it's illegal. It's illegal and unenforceable because the common law deems it on the basis of public policy, not something to be allowed. But there's an exception. And the exception is that once it is pleaded, the plaintiff the claimant in our own instance has the burden to show reasonability of the clause. Now, we are familiar with the phrase, what is reasonable depends on the circumstances of each case. That's the yardstick. And if you read some of the cases, reasonability has been determined according to geographical coverage, the time, so that contracts in restraints of trade that have been allowed to run, for instance, for 5 years have been deemed to be unreasonable and struck against. Some 3 years have been allowed. So if the Federal Competitions and Consumer Protection Act says 2 years, it comes within the general reasonability that even courts have held. I have not read that particular law to see how it applies to labor. I want to believe the law was enacted principally to deal with competition, monopolies, and consumer protection. I don't know how it applies to labor. But if there are provisions relating to labor, I want to believe 2 years is reasonable. It is within that context you must interpret our cases. I've always made the point, no two judges think alike. It's impossible. There's no way you are going to run away from the possibility of conflicting. Again, it depends on your definition of conflicting. I have access to a paper written by Justice Goodwill of the Court of Appeal. He thinks the word conflicting is itself a misnomer because no two cases are conflicting. There's always something that differentiates a particular case from another. And in the majority of cases, and I think Justice Affe made this point very strongly yesterday. I don't know whether it was here or off curve, but he made the point that, look, when you deal with judicial precedent, there's a fundamental problem in itself where most of us in the legal profession, one, misunderstand it, two, we misapply it. What is even called a ratio? Sorry, I may have to digress a bit. What is a ratio of a case is what binds you. Unfortunately, if you pick some of our law reports, whether print or electronic, majority of what comes, and I've seen lawyers do that. Oh, I am citing so-so case, make a quote and say ratio 1. The moment I see ratio 1, it tells me that lawyer is citing an editorial note. Whatever comes before the actual judgment is editorial note. And there's nothing on ground that tells you that is actually the ratio of a case. For you to determine the ratio of a case, you need to know what took the parties to court. And it is pronouncements of the court in relation to what took them to court that is ratio. Any other thing is either obiter or par incuriam. Now, some of us that are more detailed and understand some of these things, we find it very easy to get by. The same principle of judicial precedent allows a judge, for instance, to distinguish a particular case from what is before him. There's this general attitude by all of us to see it as a conflicting decision. I, for one, I do not believe, and I have seen, unfortunately, I'm bound by it, but I quarrel with it. The principle that says a decision decided yesterday and one decided today, I must necessarily apply the one of today and not yesterday. Even when that of yesterday was never cited, was never referred to, there is a criticism of us as a legal profession that ours is the most backward-looking profession. And that's because of our ties to precedents. Nobody says that a case is not precedent simply because it has aged. No. In fact, incidentally, I was talking with some lawyers and one told me he prefers to cite cases of 1960, 1970, because for him, the jurisprudence at that time was more robust, was more pronounced, was more attuned with the law, that today you don't find that. I'm not quarreling with that. All I ask for, and this includes all members of the legal profession, including those of us who are judges, all I ask for you to go against a particular decision, cite it and say why. But again, we have a problem, and sorry to say, it bounces back to lawyers. Lawyers, do a soul searching. Ask yourself a simple question. Each time I canvass an argument and I cite cases, did I in reality cite all cases dealing with that issues, particularly cases that go against the position I'm canvassing? Because if you don't bring those items to the knowledge of the judge, you are going to have all these differences in opinion that look like conflicting decisions. When a lawyer picks and chooses, only once in my 22 years at NIC did a lawyer tell me, I am citing a case that goes contrary to my position, and I want the court to take a look at it relative to what I am arguing, just so that the court can come out with only once. And I think I said it publicly last year that if I had powers to give that lawyer essay, and I'll give him for that singular act. So what do we get as judges? And again, there is this rule which I quarrel with, and I tell my colleagues. The rule is that if a case is not cited to you as a judge, there is no obligation for you to use it. I said the Evidence Act says you can take judicial notice of case law, of all laws, including case law. In fact, I had the misfortune of asking or applying a particular case to a case, and unfortunately, sorry, SAN, one of your colleagues even wrote a petition against me that why should I refer to a case and apply without giving them opportunity to address me on it. I've had that misfortune when I was in Lagos. So you see, the problem is this: when you have a rule of law that says you need not apply a case because it was not cited before you, I tell my colleagues, it has one disadvantage for us here as trial judges. One, if you don't refer to it and your matter goes on appeal, Court of Appeal can upturn you on the basis that you did not refer to that case. So I tell my colleagues, if you are aware of a case, even if the case goes adverse to you, refer to it, say why you cannot follow it by distinguishing it, just so that when it goes to Court of Appeal has the advantage of your opinion on that case, and then it has the advantage of all issues brought, and then it can make an informed decision. What am I saying? What may appear to be conflicting decisions may, after all, not be conflicting. Sometimes we're a little bit not keen about pushing. I did a paper in 2019 to judges of the Lagos High Court, and I titled it Judicial Reasoning. That paper opened my eyes to a lot of things, one of which was that both the bar and the bench had a very uncanny way of looking at some cases. And I noticed that this thing called judicial precedent was actually not being used in the real sense in which we were taught. I think it's Josephine who yesterday was saying something about precedent is not precedent if accountability is not there. And one way to show accountability is counsel that would cite a case on an issue. The first thing you need to do, bring all the cases for and against, and then leave it to the judge to take a stance. If we begin to do this talk about refer to it first, and then let the person categorically say he is going outside of it. But so long as it was not cited, I don't even think it carries the label of a conflicting decision.
No, my lord, no, my lord, my lord. No, we won't let my lord stay. We would. So that it will go around, my lord. Again, a round of applause for my lord. My lord, for the insight. I mean, rich perspective shared. And then, my lord, on a lighter note, your lordship had said that we should always cite even the ones that would perhaps not help the case of the client that were before the court. It's an adversarial jurisdiction. And then you are there to canvass your client's cases. And then you also run the risk of that being used against you. I appeared before my Lord Justice Oyewumi, and the case that I mentioned that we lost, my Lord, in addressing the issue, a small issue of whether solicitors' costs should be awarded against us, my Lord went to use my article against me. An article I published online, it was what my Lord referred to, that this was what I said in it. So very well, my Lord, we thank you, my Lord, for that great insight. And as we said earlier on, it's a hybrid session. We also have our colleagues joining us, or who have joined us online. And the questions are there. They've been coming in, as well as comments. I think before I go to the question that a colleague has asked online, and for which I've actually approached the president of the Industrial Court of Trinidad and Tobago, because it was specifically addressed to my Lord. And I would want my Lord to come and give us an answer to that. The questions online, yes. The specific question relates to, let me quickly read these comments, which I think is very good. And then we thank the court for allowing us to have this. Richmond Ideho made these comments online. This event is most commendable in shaping the labor and employment jurisprudence. I believe in the near future, we should also hold similar sessions with the justices of the appellate courts, if not all. Then the various courts, the various presidents and heads of division of the Court of Appeal, and perhaps the justice of the Supreme Court, as well as on labor and all the other matters. Hello, we thank the Lordship for allowing us to start with this. And then we say already that we are getting commendation. I mean, we're getting a comment that perhaps this should be explored by the other Superior Court of Record. Still taking a question from one of the colleagues online. The question has been asked that does law on limitation of time, limitation law or statute of limitation, as the case may be, apply to employment relations in one, Nigeria? So, my Lord, I would require somebody from the, one of my lords from the National Industrial Court to come and answer that. And also in Trinidad and Tobago, Akintunde Akinrodoye has asked that online. My Lord, yes. Trinidad and Tobago, Statute of limitation to employment, labor and employment matters.
Yeah, thanks. In Trinidad and Tobago, we do not have these restrictive rules. I was listening to his lordship about having to use the precedent and then whether you could introduce new precedents. We do not have those restrictive rules. In fact, I know in my court, senior counsel, Queen's counsel, appear more than the normal lawyers. And when they quote law, they usually use opposing, distinguishing, and things to support their case. They will present everything to the court for the court to make its decision, but we do not have any law which restricts in terms of precedent, etc. As a matter of fact, the court can on its own speak to a judgment or any situation which has been cited by law. Now, in terms of limitation, our legislation is different. We have a parent legislation, which is called the Industrial Relations Act. And then all the subsidiary legislations, whether it is on health and safety, whatever it is, those are the other legislations. In that legislation, it speaks to trade unions bringing disputes against employers, and they limit the issue given rise to the dispute must be 6 months. If it is not resolved within that time, it goes to the Ministry of Labor. At the Ministry of Labor, there is a conciliation process, etc. When that breaks down, it comes to the court. Now, the minister has the power to extend the time. So if it were to come to the Ministry of Labor 2 years after, the party can make an application for an extension of time, which is within the minister's discretion, whether to grant it or not. If it is granted, he issues a certificate called a certificate of unresolved dispute, meaning that that complaint is still not resolved and it comes to the court. But of course, we have other channels, other types of matters which can come to the court, parties can bring to the court. Another thing, the court does not recognize individuals. So an individual can, except under occupational safety and health, an individual cannot bring a matter to the court. It must be a company and a union or the government and whoever. But an individual walk in and lay a claim.
I don't remember.
I'm not sure I understand.
No, my lordship would need to, your lordship would need to explain that a little more.
Okay.
So, for example, if an individual complains of wrongful termination of employment, for example,
they go to a union. We have a lot of unions and a number of organizations are unionized. So their union will bring the complaint. If the place is not unionized, then they go and join a union and the complaint comes into the court. So the representation at the grievance level is between the union and the employer. They will engage in that kind of talk on behalf of the worker. Now, with respect to industrial relations, I think that you have to have rules that are not inflexible. So to have statutes of limitation, and then after that, you're out. To me, it's not flexible and should not be encouraged in industrial relations. Because we must remember that industrial relations are dynamic and it continues. And we must also remember, I don't want to preach, but we must also remember that industrial relations, the parties have a common interest and a common purpose. And therefore, if the courts act in a way to fracture that relationship and the parties have to go back into the workplace, we are not there, judges are not there with them in the workplace. They have to go back and resolve their issues. You're in industrial relations, judges should try to come to a just and fair resolution and not to create any further fracture in the relationship. And therefore, a judge should not be limited to this precedent, that precedent, or that precedent. The judge should be looking at best practices, even if that best practice has not been recorded in law in your judgments of the court. But because remember, jurisprudence in labor law is an evolving thing.
Dynamic.
And it's dynamic. And that is what should be encouraged.
My Lord, I thank your Lordship very well. My Lord, just before my Lord, please a round of applause for Honor. I mean, the key takeaways, law should be dynamic and flexible, at least not to restrict access to court. My Lord, the President, and maybe I should sound a caveat before my Lord that from this side, we know that right now the Court of Appeal in May 2022 in the Okojaja's case has now said that limitation laws should apply to contracts of service. So, I mean, it appears there's a guide from the Court of Appeal. And my Lord should perhaps address that together with the question asked. Limitation of action, industrial relations, Nigeria, the context.
Let me start from a little bit of history. Much earlier, when I joined the court, the jurisprudence of the court was that labor rights are not affected by the limitation law. We allowed parties to bring in matters irrespective of when the cause of action arose. Over time, our attention was drawn to, I've forgotten the case, but I think it was Justice Onogan, then as JSC, who decided that it applied to employment cases. So we had to change. Since we're a lower court, we had to follow. Then the current CJN as JSC, Justice Ariola in Ajibola, after examining all the cases from the very beginning in the 60s to date, ended up saying it is now settled. Limitation law does not apply to employment cases. A year after, in fact, there were two cases. Idachaba was the most recent, but the two were decided by Honorable Justice Abaji, JSC. Now, these two cases did not refer to Ajibola.
But the justice
Ajibola traced the history of all the cases on this issue and concluded and said it is now settled. That decision was not cited before Justice Abaji. Justice Abaji, in fact, I read Idachaba. There are two statements. One, which acknowledged the existence of older cases that say it does not apply. Then the second statement then almost and now took the position that limitation law applies. But the key point was that Ajibola was not referred to. All the decisions are Supreme Court decisions. Now, I think up to last week or so, I was made to understand, I have not seen the case. There's a particular decision Justice Obaseki gave, which Court of Appeal overturned on the ground that the limitation law applies. And I have not read it, but I'm told the thinking of the Court of Appeal is that because Idachaba is recent in time,
absolutely,
it should be followed. It takes priority over. And this is where I have a problem. Ajibola was not cited. Now, there are several Supreme Court decisions. And that's where I said sometimes we must understand what this judicial precedent is. There are several judicial the Supreme Court decisions that say a decision given per incuriam. And what is the definition of per incuriam? A decision given without reference to existing law cannot be the basis of precedent. Now, if Idachaba was decided without reference to Ajibola, can you say it was decided with reference to existing law or without reference to existing law? Now, if the answer is that it did not refer to existing law, then by the same Supreme Court, that decision is per incuriam. And if it is per incuriam, it cannot be the basis of precedent. But you see, I can only talk as an academician here.
Yes, as a law.
As somebody who is bound.
Yes, sir.
If tomorrow a case comes to me now, I have to apply the Court of Appeal decision.
Yes,
but you see, this is where the problem also comes in. Only 1 year went by between Ajibola and Idachaba. It could have been 1 day, it could have been 2 days, which means at every point in time, Court A in the or division or one panel in the Court of Appeal says this today. Today is what 7th, right?
Yes, sir.
Let's assume Idachaba was decided today, while Ajibola was decided yesterday. Can all of us in all sincerity be happy that one decision yesterday says I can do X, another today says I cannot do that X? Will we be put to hold it out as precedent? And for me, the time has come to implore on the Supreme Court once and for all, first to look into that rule that says where there are conflicting. Remember I said that word conflicting is a misnomer. But let's assume it exists. The Supreme Court must look back into that issue and tell us what really is the rationale for saying the most recent should be followed when the previous one was not cited. It just does not sound logical. While we are bound, I know that the rule is that good or bad, once a higher court decides a matter, whether it decides it wrongly, you are bound by it. There's no problem with that, but we need to understand and streamline the rules if we are to rectify the issues relating to our treatment of judicial precedent. I still believe we are not treating judicial precedent rightly. And until we do, we are going to be faced with these issues. One other area where you even have more problems is the issue of garnishing. The question whether central bank is a public person or not. If you go to Court of Appeal, you are going to see almost monthly different cases. One saying central bank is a public officer, the other saying central bank is not a public officer. And the sad part in all of that is the basis upon which even those cases that held it to be public officer are so holding, referring to Ibrahim and Kaduna JSC. Ibrahim and Kaduna JSC was dealing with the issue whether the Public Officers Protection Act should apply. And even in that act, the word public officer was never used. What was being defined was person. So when you now look at it, and then not to go into Section 84 itself of the Sheriff and Civil Process Act, take time and look at that piece of legislation more closely. You would find references to him.
And because I see there are questions on garnishing, we'll come to that.
I can as well have answered, so you jump them.
Yes, okay, my Lord.
So you see, the point is, take a closer look at that section.
Yes, my Lord.
In talking about whether the Attorney General's fiat is needed or not, it talks about public officer and uses the word him.
Yeah.
Go to the Interpretation Act. It says him includes she. It never said it includes it. So if go to the Sheriff and Civil Process Act, take a closer look. You see, sometimes we don't look at these tiny details. And they go a long way to telling us what the legislature intended. If it is not included, it's the same thing with section 46 of the Constitution, which talks about the enforcement of fundamental rights. It talks about him and certainly not it. It is on that basis that, for instance, companies are said not to be able to come under fundamental rights enforcement procedure rules, because companies can never be him or she. Forget the current usage where people now refer to countries as she. Forget it. That's not the usage. Go back to the Interpretation Act. It simply says references to the masculine includes the feminine. It never for once says it includes neutral. And until we understand some of these things, we certainly will never get the jurisprudence right.
My Lord, thank you very much, my Lord. I mean, for our own purpose, I see my Lord is dealing with even the questions and the related questions also on jurisprudential basis. Bar and bench for our own purpose, so that we know how to plead before the court. I'm sorry if I will still take my Lord back. Now, my Lord has said that, my Lord has argued, and with much force and potency, that, of course, where two judgments, in this case, we refer to Idachaba on the one hand, we refer to Ajibola Johnson, even though interestingly, my Lord, and Ajibola Johnson came 2018, the Idachaba came 2021. And at least there was a justice of the Supreme Court that was common to both panel. That's one. Interestingly, my Lord, the understanding from the Supreme Court, FC and Osakwe, were there two decisions of the highest courts, and they seem to conflict. We follow the latter. My Lord has queried the rationale, and I said with considerable potency, for the purpose of practitioners coming before the court, can we, as much as say your Lord, or your Lordship, I mean, the court is bound to allow us to choose on jurisprudential basis. Following what I said that the Supreme Court has said, we follow the latter, even though we disagree.
Can I ask something?
Yes.
Is there a system for case stated?
Yes.
Meaning that this court can go to the Superior Court, because there are two judgments so close to each other, and ask for a case stated, meaning that a larger panel of the Supreme Court will have to sit and look at it and give a proper and a final decision. Do you have case stated?
That's a way to do it. Yes, my Lord.
Yes, we have a provision for case stated, but it's now been made redundant by the principle that says where there are two conflicting decisions, follow the latter one.
That's Osakwe, that's Supreme Court.
Yes, so the question of case stated is now made redundant because it's the Supreme Court that said follow. So the first thing that needs to be done is to rectify that principle first that says follow the latter one. And my argument is this: how can I follow the latter one when this one that was done yesterday was not even referred to? Now, you ask a simple question whether we are bound. Yes, we are bound. I'll tell you what I did in one case. The same Ajibola and Idachaba. I looked at what was before me, and I made a specific finding that the issue had to do with periodicity of payment. So I first of all made a finding of fact that the injury was continuous. And on that ground, that the limitation law did not apply. Before I now went into the question whether the limitation law even should have been raised in the first place. And that was where I traced the history of Ajibola, and I traced the history of Idachaba. I brought out the finality with which they decided, and I brought out how, that's why I said I've not read the Court of Appeal decision, because I don't know whether those issues I saw in Idachaba were issues they even saw. Because if you read Idachaba, you won't be very categorical that that was the ratio of the case. You wouldn't be. I just advise, go back and take a second look at that chapter and read Justice Abaji carefully. She first of all acknowledged that, Milord first of all acknowledged that these are the trajectories of the old law, although not citing them one after the other, before making what people are holding out as the ratio. So I have a serious question mark whether that statement was actually the ratio. But I am a judge of a lower court.
Yes, my lord. Yes, my lord. I perfectly understand that.
I can only talk at fora like this.
Yes,
in my judgment, I won't be talking this way.
Yes. Absolutely, my lord. Absolutely, my lord. No, my lord, I didn't want us to get into garnish here. I said there were questions on it, but my lord said, well, we could as well take it. And my lord explained one or two things. I mean, using the example of even the live issues around garnishing proceeding. My lord, there's a related question that I would like to pose. I'm not sure it's on the paper, but I think it flows from that. I'm aware that at least the position has been settled in Dumuje and Nigerian bureaus, I mean, from the appellate courts, that when a judgment debtor files a notice of appeal and brings an application for stay of execution, it would be extended to garnishing proceedings. So put it this way, where there's a notice of appeal and there's also a concurrent application for stay of execution of that judgment. The judgment creditor is not entitled to have his day in court on the garnishing proceedings. I mean, flowing from Dumuje, and that's appellate court. Now, the way, for what I've seen, the interpretation, whether it's order 64 about of the NICN rules, when it comes to that, there's always the first order that, oh, in any event, since the appeal in many cases is not automatic, all you still have upstairs is an application for leave. So we don't have an appeal before us.
Let me tell you what we generally
I'll just
do.
quickly finish it. But also there's a decision that application in itself, the courts can take cognizance of it, because the old law, you can file an application for stay of proceedings, stay of execution on an undertaking that you file a notice of appeal, not that you don't file a notice of appeal. My lord.
First, section 47 of our act says the fact that there is an appeal is not a ground for stay. That's a statutory provision.
Sure, yes, my lord.
Naturally, by hierarchy of laws, statutory provision must take precedence over judicial decisions, unless if the decision is interpreting that provision.
Yes.
Secondly, what we do is this: we take cognizance of the fact that you are the Court of Appeal, but it does not stop us from saying, assuming we are granting even an order to pay, that the monies be put in an escrow account. Whoever wins at the Court of Appeal can then go and take his money.
Which a lot did in the CSC's case.
Yes, because what we have discovered is this: people file those cases just so as to punish the judgment creditor. Now, and I remembered vividly in one of my decisions, I said, I'm not sure Court of Appeal will say I am overreaching the case by simply saying, okay, keep this money aside. Whoever wins will come and take. So we are conscious of that. And of course, we don't want to give Court of Appeal anything on a fait accompli basis. But we still believe that for you to show, in any event, that's one of the reasons why you will pursue the appeal quickly. Because we've also had instances where appeals are filed and virtually dumped. Nobody goes there. And almost on a daily basis, I get letters from litigants. Oh, release my money. This appeal was filed and it's been abandoned. And my answer has always been, get me evidence of a Court of Appeal order that said there is no longer an appeal. And we'll release your money. So that's what we do in practice. But always appreciate the fact that section 47 of the NIC Act says The fact that there is an appeal does not mean that it acts as a stay.
Very well, my Lord. We thank you, Lord, my Lord, for that.
So our next question is around resignation during investigations. Can a worker resign during investigation of an alleged gross misconduct and still be entitled to terminal benefits? Given the fact at the conclusion of the investigation, the worker may likely be found culpable and therefore not so entitled.
All right. I see that my Lord, Honorable Justice Kadu wants to. Okay, please go ahead.
My Lord,
For the
the President, National Industrial Court, Your Honor, the President, Industrial Court of Trinidad and Tobago, I adopt the existing protocol. The question which I am going to answer is that can a worker resign during investigation of an alleged gross misconduct and still be entitled to terminal benefits, given the fact that conclusion of the investigation, the worker may likely be found culpable and therefore not so entitled. I will try, I have put something down, but I will not read what I have put down. I will just give a summary of what I have. To start with, I wish to thank the President for giving me this opportunity to participate in this discussion. The question will be tackled on two bases. First of all, on the issue of right of the claimant or the employee to disengage his services from his employment. And secondly, also the right of the employer to institute disciplinary proceeding or disciplinary action against his employee for misconduct. The law in Nigeria is very clear on the right of employee. An employee has unfettered right to discontinue with his services. And there is no law that says that he can be compelled to continue with the services that he does not want to render to his employer. The employee, all he needs to do is to tender his letter of resignation. And the moment he does that, the employer does not have any choice than to accept that resignation. And once that has been done, the contract of service has come to an end. However, there are repercussions of doing that, depending on the mode or method that the employee chooses to take in deciding to discontinue with his services. Where the employee decides to leave the services with immediate effect, then his services terminate automatically. And with that, he also loses the right to claim any benefit or termination or to claim any terminal benefit from his employer, except earned salary. That is the only claim he can make, but he cannot claim benefit like gratuity or any allowances that has not been paid to him or which he is entitled to. Our court has decided on these issues, And one of the cases is the decision of His Lordship, the Honorable President of this court, where he captured the position of the law regarding employee deciding to discontinue with his services. The case is that of beloved Patrick Anokuru versus Omatek Ventures PLC and another. It's an unreported case, suit number NICN/LA/140/2011. The judgment was delivered on the 16th day of March 2016. I have quoted certain portions of that judgment, and I will read. It's not much. This is what His Lordship said in that decision. Resignation with immediate effect by an employee carries with it three legal effects: the right to leave service automatically, the employee's forfeiture of any benefit, and the employee's paying any indebtedness to the employer. The justification for having to allow the resigning employee to leave immediately and automatically is the fact that he/she thereby forfeit any benefit he/she may be entitled to, as well as duty to pay off all indebtedness that he/she may have towards the employer. So this is the position where a claimant who is facing disciplinary proceeding decides to discontinue with his service with immediate effect. So when we apply the provisions or when we apply the principles enunciated in this case, it will be correct to state that an employee facing disciplinary proceeding for conduct may decide to quit by resigning his appointment with immediate effect, and the employer has no choice rather than to accept the resignation, thereby ending the contractual relationship. Where an employee adopts this method of immediate resignation, he forfeits all his benefit except the salary that he must have earned. And His Lordship has in another case clarified what kind of benefit concerning the benefit. He has defined the benefit that an employee is entitled to and the benefit that he is entitled to. The case is that of Dr. Dave Onwabo versus Oil Flow Services Limited. Is a reported decision of this court in suit number NICN/LA/552/2015, delivered on 10th of July 2017. However, where the employee resigned with notice, as a general rule, the disciplinary proceeding continues. That is to say, the employee can still be disciplined since the notice he gave has not expired. So if an employee decides to quit the services, but decided to do it by giving notice to his employer, the employer has the right to discipline him within that period of notice. And if at the end of the day he was found culpable for the misconduct which he was charged with, he can be terminated or dismissed from service of his employer. However, if an employee if an employee is forced to continue with the services, that is to say the employer refuses to allow the employee to end the services, that employer may be guilty of forcing the employee to be under forced labor, and that will be against the provisions of Section 34 subsection 1C of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Section 73 of the Labor Act. These similar provisions can also be found in the ILO conventions, Convention on Post Labor, Convention number 29 of 1930 on post labor, and that of abolition of forced labor, Convention 105 of 1957. All these conventions and the provisions of the law prohibit forced and compulsory labor. So where an employee is denied the right to disengage, it can be argued that he is under forced labor, and that is against the law. In conclusion, I wish to state that an employee that decides to resign his employment during pendency of disciplinary action loses the right to terminal benefit, save and salary, while an employee who gives notice of resignation has exposed himself to continuation of the disciplinary proceeding to conclusion and may face the risk of being terminated or dismissed from the service during the period of notice. Thank you very much.
Thank you, my lord. So we have a follow-on question from that. You did say when the employee resigns immediately, he forfeits his terminal benefit or she forfeits it.
Yes.
If they give notice, then no, the process can go ahead.
Yes.
So where the employee gives notice,
Yes.
but gives notice that is less than the contractual provision, so are they treated as having been given notice or having resigned immediately? So for instance, I'm supposed to give 2 months notice and I give 2 weeks notice. Did I give notice or did I not give notice?
No, when I said if he gives notice, that is, he did it in compliance with the terms and conditions of service. Okay. But where he did not comply with the terms and conditions of service, then he has not properly disengaged himself.
But if the contract allows him to pay in lieu of notice and he pays,
if he pays, that is the end of the contract of service.
And
he cannot be susceptible to any disciplinary proceeding. But here, where he did not pay the salary in lieu of notice, then we can say that the contract continues and he can be disciplined. But where he decides to pay, it means he has fulfilled all the conditions and he cannot be subjected to the disciplinary procedure. And in that case, if he has complied with the proper condition, he can claim his entitlement.
Okay. Thank you.
Thank you very much, my lord. It's a Bar and Bench Forum. I'll crave the indulgence of my lords to, at this junction, call on senior member of the NABA, my Dr. Roland Otaru, SAN. So please come and share with us some comment on the establishment of the NICN under 254 as it relates to the labor force and related thoughts on the establishment of the NICN under the section, how it has created, if any, shifts in the workplace. Yes, ma'am. Yes, NSC.
Thank you, my learned brother Silk, in whom I am well pleased. The gentleman par excellence, with your intimidating humility, the president of the National Industrial Court of Nigeria, my very good friend, Honorable Justice Bibi Kaib, PhD, the president of the Industrial Court of Tobago, Trinidad and Tobago, Honor, Deborah, Thomas, Felix, my lords of the National Industrial Court, the best thing that has happened to the labor force in Nigeria, and of course the employment space, is the promulgation of Section 254C of the 1999 Constitution as amended by the Third of Treasury. The provision expanded the jurisdiction of the National Industrial Court. What we are enjoying today is because of that enactment. A lot of decisions that have been given by this honorable court, by the National Industrial Court, has really brought succor, peace to the employment market or labor force. For instance, the decision in Sahara Energy Limited and Oyebola, a case that I was privileged to have handled before my Lord Honorable Justice J.D. Peters. It has changed the narrative of the issue of award of damages to an employee, because hitherto you talk about payment of 1 month's salary in lieu of notice. That decision was affirmed by the Court of Appeal in ensuring that it cannot be business as usual, 1 month's salary in lieu of notice, having regard, although it must be based on the circumstances of a particular case. And again, there is a recent decision by my Lord Honorable Justice Basi, the case of Professor Babatunde Sholagberu and the Lagos State University. That decision was given or was delivered on the 22nd of August, 2022. And if you have the opportunity, go through that judgment. The plaintiff was restored as the provost of College of Medicine last year. I am saying this because, but for the enactment of that provision, and again, because of the robust judgments of the judges of the National Industrial Court, there would have been chaos in the labor force in this country. I am using this opportunity, Mr. President, to commend the judges of the National Industrial Court for what I would describe as using or employing the meek of human kindness. Excuse me, because yesterday there was this issue of using human kindness, which the president debunked. But I want to say without any equivocation that the judges of the National Industrial Court have what I can describe as having the meek of human kindness. And why did I say so? When you employ or when you use the international best practices, it means you have meek of human kindness. Because international best practices, though is entrenched under Section 254C of the Constitution, but it also means that if there is no any way you can give a favorable judgment to a plaintiff, for instance, you have to resort to that convention. And so I must say, we in the legal profession, we are very proud of this court. We are proud of the judges of the National Industrial Court because the judgment coming from you, they are very robust and very cerebral. Once again, I am saying this without missing words, because if you take time to read the judgments of the judges of the National Industrial Court, you will see the depth of knowledge, the depth of research inherent in those judgments. And in most cases, most of the judgments are not normally set aside. They are normally affirmed by the Superior Courts of Record. So once again, Mr. President, I thank you for this initiative of Bar Bench Forum, and I hope it will continue and it will enrich our knowledge. It will, to a very larger extent or a larger extent, enrich our jurisprudence. Thank you.
Thank you very much for that intervention. Just to say that if you do have a question and you're here with us, we have volunteers who are going around with pieces of paper, so you can write your questions. We do not intend to take questions in person. We're just going to read them out. So if you do want papers, you can raise your hands up. Max, we'll get it across to you. So we have another question from our colleagues who have joined us online, and this is from MMS. Based on the limited scope of the definition of workers under Section 91 of the Labor Act, which excludes persons exercising administrative, executive, technical, or professional functions as public officers or otherwise, can the courts apply the law to all other employees?
Yes, the Section 91 of the Labor Act defines worker restrictively. What I tell people is this: first and foremost, the Labor Act is a Labor Standards Act. though it was enacted in 74 and it's outdated, there are aspects of it that are still relevant. Now, if you look at the sections in the Labor Act, there are sections that use the word person. There are sections that use worker. So when those sections use worker, of course, you must rely on the definition of worker for purposes of applying them. But when the section uses the word person, then it is of general application, which means even if you are not the worker defined, you could still be affected. But more importantly, where we have to deal with an issue that is not specifically provided for in the contract of employment, nothing stops us using the Labor Act as a yardstick for determining the standards that should apply. So see the Labor Act first and foremost as a Labor Standards Act before specifically in terms of the provisions looking at whether it applies to workers or to persons in general.
Thank you, my lord. And flowing from this, we do have a question on redundancy. Now, the lettering and the provisions of the Labor Act say it's bare and hardly provides any guide on redundancy payments. Again, this has been borne out in the suit between Sopenyi Olasipo and the Association of Senior Staff of Banks, Insurance, and Other Financial Institutions, the judgment of which was delivered on 26 September 2022. But how can or how should a practitioner or lawyer before the court plead a case on redundancy to a successful outcome on payments? Because the law is silent on this.
We all listened to the NLC president. He put down the parameters for looking into redundancy. But more importantly, aside from Section 20 of the Labor Act, there is no other provision, no other regulation on redundancy. This is where I thought, but I am yet to see that lawyers will take the initiative. The court has leverage now to apply international best practices, to apply conventions, treaties, recommendations, and protocols ratified in Nigeria. I am yet to see a case filed by a lawyer built on either international best practices or conventions dealing with redundancy and urging the court, based on its power and jurisdiction over these issues, to determine the matter on that basis. I am yet to see. So what am I saying? We don't have local legislation or regulations telling us the parameters other than first in, first out, consultation. Other than those three parameters you find in Section 20 of the Labor Act, nothing else is stated. So if there is one area of law where lawyers can fight it on the basis, let's assume an employee quarrels with how he was treated on the basis of redundancy. It behooves his counsel to do the research and find out how do other jurisdictions treat that issue. Make his case on the basis of that and come to court. The defense will look at it and now bring its own viewpoint in terms of other countries, how they have done the different or the opposing thing. And like I said, you then allow the judge to determine. Each time the court decides that a matter is on the basis of best international practice, like Section 7(6) of the NIC Act says, what is international best practice is a question of fact. And once a decision is made as to a finding on the question of fact, you cannot appeal against it without leave of the Court of Appeal. So if there is one area where international best practice ought to be used by lawyers to fight causes and matters, it is redundancy. And that's because the local legislation does not say much in relation to it.
Thank you very much, my lord.
Lord, indeed, that is very useful insights, and I'm sure we've learned a lot from that because it's an area that I've also tried to grapple with, that we don't see is an issue that comes up all too often.
And let me just point out something. The president of the Industrial Court of Trinidad and Tobago stressed the fact yesterday. The starting point for determining international best practice is the ILO.
Yes.
That's the starting point. Because of the nature of the tripartite setup of ILO, you have governments, you have employers, you have workers. Each time they agree on a standard, that prima facie is evidence that that standard is best international practice. Of course, the defendant now has the duty to show how, maybe by going into the archives in ILO to show the opposition that was made to it. And then, of course, there are some standards ILO does that gives leverages for individual countries to alter one or two things according to their local circumstances. So the defense will bring out all this to say, no, despite the fact that it was passed, this is what ILO said. We can change it based on local circumstance and so on. And then at the end of the day, the court is allowed to decide.
Thank you very much.
We have another question. In what circumstance would the employer be made vicariously liable for workplace sexual harassment claim made against a staff or an employee by a co-employee?
Justice Obaseki is our expert in that area.
Lord.
I love the president.
Yes, my lord. The question is, I thought that now that the mic has been passed to my lord, before my lord answers that, in what circumstances would the employer be made vicariously liable? Because I remember that in financial reporting, which my lord decided, my lord had asked that a specific individual who was alleged did not come to testify. There was HR.
No, I think it was my Lord Justice Oyewumi.
Okay, my lord, yes, okay. So there's some bearing there, my lord. Yes, my lord. Is my lord just
first of all, when we're looking at sexual harassment and vicarious liability, we cannot look at it now without mentioning Convention C-190, Violence and Harassment Convention. And the focus of this convention is on inclusivity. In other words, everyone in the world of work is protected. So you are working, you cannot be sexually harassed in the workplace. And of course, we know that conventions, recommendations, treaties, protocols, they're evidence of international best practice. So it is a best practice that you must not be sexually harassed at work. Then, of course, I'll go straight to the point that we have made extensive provisions in our rules of court. Order 14 of our rules of court tells you what to do, what to plead, the claims, so you know what exactly you are filing. Then, proof of employment relationship. You can't be filing such a matter and then you have not shown the court that there's that employment relationship. So as it is today, in the workplace, there's zero tolerance to sexual harassment. And so where a report is made by an employee, usually, I must not forget to say, in the world of work, sexual harassment usually is from a superior officer to a subordinate, usually in the world of work. So we're looking at it from that prism. So when there's a report of sexual harassment made by an employee, it behoves on the employer to investigate that report of harassment. Where the employer fails to investigate and take action, in that regard, then you could say that the employer has tolerated it and is complicit. So it is very important for the employer to investigate, and where the harasser is found culpable, punish the harasser. But where the victim's complaint is not investigated, and of course, because the harassment is coming from a superior, the victim is disengaged or terminated, and the victim comes to court, then the employer has a lot of work and trouble on his hands. So that's where the issue of vicarious liability comes in, because the employer has a duty of care to the employee to make sure that the employee is all right, the general well-being of the employee at work. Where the court finds that this has not been done, remember that there's that in vicarious liability, there's that apparent authority. The employer has given this superior officer that apparent authority. So the officer or the harasser, let me use the right word, the harasser is using the apparent authority given to him or her in the workplace to commit or harass this victim. Where the court finds that, where the claimant, in this case, I assume the victim, is able to satisfy the court that all these exist, employment relationship, I reported, nothing was done, the breach of the employer breached the duty of care, I was terminated, my harasser was my superior officer. We have a case of vicarious liability staring at us. Thank you.
Thank you very much. Thank you. So the provisions of Section 254C of the Constitution, as amended, and Section 76 of the National Industrial Court of Nigeria Act have been celebrated for the additional powers they have granted the National Industrial Court to apply international best practices and international labor standards in determining disputes between employers and their employees. Are the court's powers circumscribed by other considerations, and are there steps employers must take to benefit from the provisions of the law?
My Lord, Honorable Justice Oji.
Thank you, my Lord the President. My Lord the President of Trinidad and Tobago also. The question is on the provisions of Section 254C of the Constitution and Section 7C of the NIC Act, which clearly and admittedly has given extra powers to this court to apply international best practices and international labor standards. Now the question whether the court's powers are circumscribed by other considerations. Well, first, I'd like to say that the provisions of the statute cited are clear on the powers they have granted the court. Now, whether these powers are circumscribed will just arise from what commentators, have been saying about the powers given to the court. And most times it derives from the provisions of the same Constitution in Section 12, which creates a money's polity for the country, and which requires that every convention or treaty must be reenacted before it can be applied. Now, that's the dualist policy which Nigeria applies. But in this same constitution, and by this third alteration, this same constitution has now deviated from that monism to embrace a dualist approach with respect to labor issues. So when it comes to labor matters, this courts can, the powers of this courts are not circumscribed by that initial provision in section 12. So these courts can apply international labor standards and international best practices directly once those labor standards, which are found in conventions, in declarations, in recommendations, mostly from the ILO, once they have been signed by Nigeria, this court can apply them directly, even without domestication. So we don't see that there is any provision in the Constitution that circumscribes the ability of the court to apply these international standards and practices. But the only thing I'd like to add is that with respect to international labor standards, this refers to adopted treaties, which have become law, which we can apply directly. But for international best practices, it has been said already that practices which have improved. And so the litigant, I want to say use the litigant because what is used here are steps employers must take. But I'd like to add employers and employees, the steps they must take to benefit from the provisions of this law. For international labor standards, there are already laws that can be applied by the court, so they don't need to take any further steps. But for international best practices, they'll have to plead those practices. And like my president said yesterday, in the pleadings, it's expected that you state that these are practices that have become applicable internationally. And if a practice is in the recommendations of the ILO, it shows that, yes, this is an accepted international practice, which if it's pleaded, then and proven to be so, in addition to also show that the vast majority of the international community are also applying these practices in their municipal laws, then this court can say that it has been established, that practice has been established, and it can be applied. And apart from this, the pleadings are proof, there are some international practices that are notorious. And so this court can also take judicial notice of those notorious practices and can apply them. So, so there are no such things, no such considerations, except the considerations of justice, which we all apply. So this court can really and readily apply international labor standards and practices. Thank you.
Thank you very much, my lord. Okay, my lord, went from a colleague in-house, I mean, someone who's here, he's asked a question, or is casual workers. No employer should engage the services of a person as casual worker beyond 7 months. There are situations where employers in Nigeria keeps casual workers beyond the 7 months without letters of full employment, and sometimes after using them for years, sack them without any benefits. Can such a casual worker make a case before the NICN? Now, because of time, I would like to read another question because I think this is so that both can be taken together. Yes. Then there's also a question that from Richmond. What can the NICN do with regards to the conservatism of the appellate court as regards the activities of the NICN? This is because while the NICN would apply international best practices and treaties on labor and employment in arriving at a paradigm shift in labor and employment jurisprudence, the appellate court, however, still applies a strict common law. What can be done to create consistency in our labor and employment jurisprudence? They are not exactly related, my lord, but I was hoping that we could have a bite.
Thank you. On the casualization thing, until the matter comes, there is nothing we can say or do.
Yes.
We are not so sure the circumstances in which they were employed, because sometimes those you define as casual staff are actually outsourced staff.
Yes.
And because they are outsourced staff, they are staff of the company outsourcing them. So the question of casualization becomes difficult to establish. But as to what will happen, until the matter comes, we can't say what will happen. It comes, of course, based on the facts before us, and then, of course, whatever defense the defendants will bring, that will determine what will happen. It's difficult to say here what position the court will take on an issue like that.
But my lord, I mean, whilst my lord was on that, a question which I think is exactly related just came. And I was hoping that, or perhaps my lord would want to attempt that alongside with this, because it appears that it's always a live issue.
Yes.
As it stands, and this is from Mr. Monday IJ, who is the NBA Buhari branch chairman. As it stands, one of the ingredients to establish in court is for the employee to plead and front-load his letters of employment. So we're talking about casualization, and this is where I think the link is. The courts increasingly ask that the employee plaintiff or claimant should plead his letter of employment before he can succeed in his or her claim before the courts. My question is, can the court depart from this common practice by relying on other means, showing that indeed such relationship exists without necessarily pleading or tendering the letter of employment, considering the fact that foreign companies, for example, are in the habit of not even issuing those letters of employment?
We recognize that there can be employment by conduct, but the only problem you have is proof. You are aware that if the claimant comes to court now, he says, I was employed by this company, and he says, I was not given the letter of employment, and the defendant pleads that we never employed him. If he does not get some other person who will corroborate him, of course, on the balance of proof, it's his word against that of the defendant. Unless he can show, take for instance, okay, you employed me, were you paying me through a bank? In which event, if you bring your bank statement to show monetary entry as salary, that would be evidence of it. I remember there was a particular case where something similar happened, and it was Justice Diggy, then JSC, who dissented. But the other justices of the Supreme Court held that once you have pieces of evidence here and there showing an employment relationship, the necessity for a specific type of employment is not needed to show the relationship exists. But Justice Kutidi was very clear that no, a letter of employment is first and foremost required for you to even have access to court. But like I said, his was a dissenting opinion. But today, we recognize that there can be employment by conduct. The only problem you have is proof. Because matters that deal with evidence through word of mouth are generally speaking required to be corroborated. Who decided in one case that particularly when you are making claims for special damages in employment, you have to be very careful where the evidence is the ipse dixit of the claimant. Very often that you require corroboration for it to be able to. And if you read some of our cases where we establish that for claims in special damages, two requirements are needed. One, you must prove entitlement. We made it very clear that entitlement is proved by reference to an instrument. It could be a letter, it could be an act, it could be the contract of employment, or it could be a circular if it is dealing with government. And then the second requirement is you must prove the quantum of what you are pleading. If you don't prove these two requirements, almost invariably, you will lose out. And we also stress the point that in proving your entitlement or the quantum, oral evidence is not sufficient, except it is corroborated.
So much, my lord. Okay, then the one on conservatism.
The Court of Appeal,
Yes.
well, we're a junior court. There is hardly anything we can do. We are bound by what they do, but you can elevated. We succeeded in having Justice Amadi go, and there's a new exercise that's just been opened up. Some of our judges have indicated interest. We'll push it and see whether we can have a second going to the Court of Appeal. Our belief is that if we have some of us go up, makes it easier for them to sit on panels dealing with matters coming from National Industrial Court. And if that happens, it makes it the more easier for them to be able to appreciate where we are coming from, why we do the kind of things we did. I'll give you a simple example. I think yesterday, the case of Oboboso came up. The case said Section 12 of NIC 256 of the Evidence Act. There's a decision Justice Amadi did this year where he distinguished that case because in Oboboso, the Interpretation Act was not referred to. But this other case decided by Justice Amadi referred to the Interpretation Act, where the Interpretation Act says, where in an act reference is made to another act, and that act is repealed and replaced by another act, then in this act, all references to the repeal act must be interpreted to mean references to the new act that replaced it. So the argument that NIC Act is not, Section 12 is not compatible with Section 256 of the Evidence Act because the Evidence Act is 2011, while the NIC Act is 2006, cannot stand the Interpretation Act. Again, this typifies the kind of example I gave about what people call conflicting decisions. If you see Justice Amadi's decision now and you see Oboboso, the tendency is to come to the conclusion that both cases are conflicting. But the truth of the matter is that Oboboso was decided without reference to the Interpretation Act. So the one decided by Justice Amadi cannot be said to be in conflict.
And in any event, the latter one, that's Adeboye, specifically referred to Oboboso.
Yes. And said why it was not following it.
Thank you. We want to take a couple of questions in relation to employers. And so the first question is around what constitutes international best practices evolve over time. For instance, telecommuting was not necessarily before COVID-19 forced workers indoors. How should employers prepare to move with the times? What tools should employers possess to monitor employee compliance while telecommuting? What liabilities are employers likely to bear as workers telecommute? And following from that also, it does seem as if the entire gamut of labor and employment law speaks majorly to employee rights. Can it then be said that employers have rights that can be protected by labor?
Well, we are looking at telecommuting, and I can see that you put in brackets working from. We know that employees who work from home tend to be happier, less stressed, and more productive. That's what the statistics tell us. Working from home or telecommuting or remotely or whichever word you want to use for it has come to stay with us. And outside Nigeria, in the United States, in Europe, it is a fact that people are working from home. Sometimes 3 times a week, 4 times a week. So it is a fact that because it is of global importance now. what should they do? The first thing for an employer to do, and I'm going to look at Nigeria. Here in Nigeria, but there are quite a number of organizations that have allowed their staff or employees work from home. Sometimes 4 times a week, sometimes 3 times a week. So it is already happening here in Nigeria, especially the foreign companies. An employer in Nigeria, what does he do? The first thing to do is to look at your conditions of service. Do you have a provision for telecommuting? That's the first place to start. The employment agreement. Hitherto, there was nothing like telecommuting. So in the employment agreement today, you need to have a clause or provision, something that is dealing with telecommuting. And there you must have the guidelines, the parameters for telecommuting, for example, how many hours, and so on and so forth. But most importantly, before I forget, the most important thing is that the employer must have its own private virtual network. Because you want to be able to monitor your employees. So you must have your own private virtual network. And that means you are going to provide work laptops. And of course, all the work laptops are going to be configured. So employees, don't think that you can just take your boss's work laptop and then think you can just go on a frolic. No. So those are the places to start from. And then you need to monitor. How do you monitor? There are a lot of apps. There are a lot of tools. Why is the employer monitoring? The employer is monitoring because he wants to ensure that that employee who's working from home is productive and actually doing the work. So software tracking systems are going to be there. The employer is going to be looking at your activity on your worktop or your laptop, your mouse, your keyboard. All those tracking devices are going to be there. Your email activity. There are apps that track your email activity. Your focus. The employer wants to know, what are you focusing on when you say you're at home, working from home? What is your focus? The employer needs to know all of that. The time you are spending. So time tracking software, the employer is going to need to have that. Those are just some of the tools and software the employer is going to use to monitor your activity. Then you also asked, yes, what tools? Well, okay, tools, you'll be looking at things like Zoom, Microsoft Teams, Google Chat, all of these things. And I must stress that usually the host of these tools have the ability to see and monitor everything that is being done by the employee. So that is where the employer has the upper hand. Then you have, you say, what liabilities are employers likely to bear as workers telecommute? One of the things that the employer will need to think seriously about is the hours of work. It has to pay. Because otherwise the employee comes and says, I work so hard. I work from whatever hours to whatever hours. So in your agreement, you are going to state the time. Is the employee going to be allowed to log on before regular working hours and after closing hours? Then, of course, another liability, which the employee would accuse the employer of, those long hours, invasion of my privacy. I mean, I don't have any space. Completely, my privacy has been completely taken over. That is why the employment agreement, the conditions of service must clearly state all of this. And of course, we know if you are using your employer's work laptop, you're using a work laptop, you can't be doing your own private surfing on the net because everything is going to be seen by the employer. I think I will stop there for now. Yes.
Well, thank you very much. My Lord has actually addressed a lot. My Lord indeed has addressed a lot. And I mean, we pray the infrastructures are there to enable the employer put all of this in place. But as my Lord spoke, I imagine what is perhaps likely to be a live issue at some point. The Employer Compensation Act was made in 2010. I mean, long before COVID-19 happened. But interestingly, accidents, the expansive definition given to accidents in that act can perhaps avail an employee working from home who claims that from getting up to use the bathroom, slipped, and there is a workplace injury because accident there was defined anything carried on in the course of work. That work was not a physical building in the course of work. And then we're talking about it. Imagine when it's thrown up before the industrial court that, and it's seeking to rely on the Employer Compensation Act that accident there envisage this, and we can use it in today's context. So still, how the court will help to manage the employer's liability along that line.
Well, we know we are looking at international labor standards, international best practices.
Yes,
we know that the work is not just physical. The workplace and the workspace is also virtual.
Yes.
So that virtual workspace, I am sure and I know because of all the tools that the industrial court has to apply, international best practice, we will find a way. When that issue comes, we will deal with it. I can assure you.
Well, thank you very much. Okay. Yes, and related to that, still for the employer, I think lawyers for the employer, they've also asked. There was, where is the second one? Yes. Okay. No. My Lord, the question has been asked that our employers, Mr. Bayo Mole has asked now that our employers bound by the strict rules of evidence during disciplinary proceedings. This is as it pertains to confronting one's accuser.
The Evidence Act applies only to courts.
Yes, my Lord.
Only to courts.
Okay, maybe let me rephrase. The question was asked that evidence. I reckon that what he meant was perhaps rules of fair hearing and all of that.
Even the rules of fair hearing, I'm sure you're aware that it's a Supreme Court decision,
yes,
which says because Section 36 talks of courts and tribunals, domestic tribunals are not domestic courts and tribunals established by law. That's what Section 36 talks of. And that particular decision, I think it deals with one professor, yes, where it were very specific that the domestic disciplinary tribunals are not caught up under Section 36. And I need to make a point here. If as a lawyer, you frame a case and the case is specific to an employer breaching Section 36 of the Constitution, you may not succeed.
If as an employee,
But if you frame your question or your case on the basis generally that an employer breached rules of fair hearing, then you would be allowed to go to the common law rules of fair hearing and make your case. But if you're specific that it is section 36 of the Constitution that is breached, then you are going to be met with this Supreme Court decision that says domestic disciplinary tribunals are not covered by section 36 of the Constitution.
because I'm aware that, I mean, I have seen a couple of judgments from the industrial courts where the issue had been that in the disciplinary reports of reviewed that in the course of the disciplinary proceeding, the plaintiff or the accused was not given an opportunity of cross-examining the accuser.
Of fair hearing, not section 36 of the Constitution.
My Lord, at this stage of our nation's socio-economic development, and I'm happy that the court is also looking at socio-economic development. The question has been asked, is there any need for inclusion of social media use policy in an employee's handbook? If no, why? If yes, how much of policy rules should be focused on regulating an employee's use of social media, bearing in mind the regulation or the need to also maintain a fair, delicate balance, not to breach rules related to privacy, data protection, and all that. And already is the Nigerian courts, is the industrial court to deal with the challenges of social media in terms of technical understanding of our judges. I'm tempted to leave out this part because my Lord Honorable Justice Obaseki Osage was today talking about Teen, Zoom, and all of that, and credibility of evidence gathering and general legal framework.
Of course, there are 1,001 things that should go into service now. Yesterday, I said something about tattoos and things like that. If you go to an average conditions of service of an organization, you don't find those things. I've always told employers, you must take a second look at your conditions of service and put those things that you don't want. Because if you come to us, the first question we are going to ask is the conditions of service having a provision prohibiting what you are saying you did? I always like to make this statement that in administrative law, human beings are permitted to do anything except that which is specifically prohibited. But for artificial entities, you are permitted to do only that which you are permitted to do. Every other thing is prohibited. So if you want certain things in your organization, put them in your conditions of service or in your policy. Because if you don't, the assumption is that you are prohibited from insisting on those things. So if an organization thinks it wants to bring in social media policy into, it's free to go ahead and do it. Of course, don't forget, subject to the basic rules of unfair labor practice. Some of these provisions may be tested against the principles of unfair labor practice. So that whatever you do, when Milord Joseph was talking, she said something about you are allowed to work from work. You are, from home. Don't forget, ILO's working time is 8 hours per day. So if you go beyond 8 hours, is that fair labor practice? Particularly when you go beyond 8 hours without extra pay. These are considerations that you have to factor in. So it's not a straightforward answer to some of these things. The circumstances at the end of the day and how it plays out. And I must make this statement, and profoundly. Yesterday I said something about the destructive effect of digitalization as to the future of work. Some of the things were what Justice Obaseki pointed out. Don't forget, digitalization now has blurred your working time and leisure. You leave the office. Apart from computers, offices give phones. You leave the office thinking, now is my time. The phone rings. Your boss wants you to do something and report back in the next 2-3 hours. Your boss is asking questions about work while you are in traffic. That's an infringement of your leisure time. How is that to be sorted out? Should it be simply compensated for? Or should it be outrightly deregulated and said, look, don't even do it? And I made a statement yesterday about the time has come for ILO to begin to consider a convention on digitalization itself and the world of work. Because apart from some of these little things we are pointing out, there are more serious issues. I pointed one or two out yesterday. You have digitalization, you don't even know whether the person that is working for you is actually an employee. Very often the employer gives you that job in circumstances that he calls you an independent contractor, so that you don't enjoy the benefits of employment protection or some other regulation. So there's a whole world of problems associated with digitalization and the world of work that requires more serious discussion. I know the discussions are started in ILO, but they are yet to come with conventions on it.
My Lord,
that's additional.
Yes.
I just want to say that, as His Lordship has said, if you want to institute and implement a policy on social media, etc., that is internal to you. But in my mind, that policy cannot be implemented without consultation. So because good industrial relations tells you that unless the person is now coming into the organization, the person would have had an existing employment contract. And therefore, if you have to alter those terms and introduce policies, new policies, you need, if there is a union, to have consultation, or if there is no union, you need to consult with each of the workers who would be affected by it. And another thing that came up a while ago, the question, the way you asked your question, I think you were more interested in the rights in terms of the disciplinary hearing.
Yes.
Always remember, or the alteram partem, natural justice. So the person will be entitled, whether the disciplinary trial or whatever you want to call it, hearing, is structured in a particular way or not. The person is entitled, one, the right to be heard, know who his accusers are, get the statements, if there are any statements, full disclosure before that disciplinary hearing is conducted. And His Lordship is quite correct. How you structure it and the formality of it and all of that is not important in terms of evidence. What is important is all the alteram partem, that the person knows his accusers and what he's accused of.
Interestingly, a question just came in, and directly we want to draw from Trinidad and Tobago. Can a remote employee join a union? Will he be entitled to take benefit from the collective bargaining agreement? I will appreciate the opinion of my Lord, both for Nigeria and Trinidad and Tobago. Remote employee. Yes. I mean, someone who is working from home. Yeah. Yes. Join the unions Question is also clear because telecommuting involves coming to work, attending physically, and then from home. But the question says, can a remote employee join the union? Will he be entitled to take benefits from the collective bargaining agreement? I will appreciate the opinions of my lords from Nigeria and Trinidad today.
In my country, collective bargaining is compulsory and written into the law. When the legislation came into effect in 1965, collective bargaining and compulsory meeting and treating and having discussions. Collective agreements are therefore binding on parties registered at the industrial court by the president of the industrial court, and it becomes the rule of thumb, unless of course it goes against the law. But we have lots of legal departments which will vet, and the Ministry of Labor will vet to ensure that the document is legally sound. Right. Now, whether some organizations with the advent of COVID has accelerated remote work, but remote work was there before COVID. Some organizations, the persons have already been unionized, and therefore they will continue to have their union. And some who are not unionized can join a union. In February of 2020, I addressed trade unions from Latin America and the Caribbean about how remote work poses new challenges for trade unions and their membership, because it is clear that with remote work and small contracts labor, that there's a dwindling in trade unions membership. It does not preclude you from joining, but some persons rather deal with the employer and sort themselves out and then get a lawyer.
From the Nigerian side, the problem will be similar. The problem will be similar. Remember yesterday I said something about trade unions must begin to reorder their priorities and see how they can capture this area. Now, if you look at the Trade Unions Act, for instance, the definition of a trade union, and in terms of its membership, it defines it by reference to the existence of that group of people called employees. Now, very often, and this is one of the problems of digitalization, these people who work remotely, firstly, are not even regarded as employees by the people they work for. So there is a first problem of situating them within the category of employees before determining which unions they would join. So when we made the statement that unions need to be proactive, some of the issues is that they need to begin to take this reality into place for them to know how to reorder the question of unionization of people at that level. If you look at our union system, take for instance the road transport workers. Very often they are in quotes, not workers as we understand them. They are self-employed. Our definition of unionism in Nigeria presupposes the relationship of employers and employees. And that is why for every workers union, for every employers association. Now, if you're dealing with a group of people who are neither employees nor categorized in those, you are now having a problem with the basic structure of unionism. Who will be the counterpart employer association? Because these are the practical problems, legal problems but the discussion has to start. Because when it starts, it's not going to be NIC that is going to propel the solution. NIC will only come in when they have suggested something and the question is legal recognition. Then NIC will look at the reality and be able to.
But rather, before I let my Lord go on that, the question just came in related to trade union. What is the attitude of the courts to the provisions of the Trade Union Act, which says that employers considered as projection of management may not be allowed to join the union?
It's a rule in the Trade Unions Act that if you are a projection of management, you are not allowed to unionize. It's not strictly, it is not that you are not allowed to unionize, you cannot go on strike, strictly speaking. We've done one or two cases. I think we did some years back in Enugu, but that had to do with the judiciary. And we held that people in the rank of directors in the judiciary were projections of management and so cannot claim unionization or the right to strike. The question of who is a projection of management is usually a question of fact. And then it depends on the actual role that person plays. And I'll give you a simple example. Because it's usually also hold that his secretary is a projection of management. And the secretary may be a junior level staff. So it's not a hard and fast rule. It's usually a question of fact that depends on the circumstances of each case.
Now that, my Lord, well, I mean, employers, everything is about they're not allowed. So the question go back to the questions that are coming before now. And now about employers. Can it be truly said that employers have rights that can be protected, but that are protected by labor law and or by the NIC? Employers' rights. Because it appears all along is the employee.
Which question exactly?
That's number 14.
14.
Yes.
Just a minute.
Okay, I think my Lord. Okay. Yes, my Lord wants to have it. Yes, my Lord, we're coming to Trinidad and Tobago. We want to start with Nigeria so that once we have the opportunity of what the employers' rights are, we'll now come to Trinidad and Tobago so that we'll commend it back to the court here that this is how the employer is getting away in Trinidad. Please, my Lord. Because the concern now is Nigeria. Yes. Employers in Nigeria.
All protocols duly observed. Good afternoon, ladies and gentlemen, your lordships. Talking about employers, the employment contract generally tends to create a relationship between one who has power and another who has no power. The law aims to counteract the inequality of the bargaining power, which is inherent in most employment relationships. The principal purpose of labor and employment law is to regulate, to support, to restrain the power of management and that of the organized labor. This does not mean that employers have no rights, because where there is a right, there is a corresponding duty. And when there's a duty, there is a right. So in contrast to employment, in a contract for employment, these two elements constitute the terms of labor and agreement. Employers have rights which are protected, just like the rights of the employees. I will give some examples of the rights of the employers that are all protected duly by the law. The right to obedience of lawful instructions by employees. Any disobedience may amount to substantial disregard of the employment contract, which entitles the employer to dismiss that employee summarily. Number 2 is the right not to be unreasonably absent from work and to perform duties diligently. And number 3 is the right of the employer for the employee to use
kill and care for himself and for the protection of other workers. His employee, where the conduct of the employee is not in the interest or the continued interest of his employers or of that employment relationship. There's no legal list of what constitutes the degree of misconduct to justify dismissal. But dismissal can be for any of the following reasons. One is incompetence, two is gross negligence, another is misconduct. We have dishonesty, falsification of documents, and many others. So the foregoing is not exhaustive. The determination of employers' rights to be protected will be contextual. And as a matter of fact, is as the need arises, because it arises from the breach of the obligation. The rights of the employers usually arise from breach of the obligation of the employees. And that's where the rights of the employers generally arises from. When the employees breach the obligations, their own obligations, the rights of the employers arises. Thank you, gentlemen.
Thank you very much. My lord, there are two comments. One is a suggestion from the courts, also from the chairman of the NBA Borough branch, Mr. Aji, who is suggesting that the court should establish a department within the court premises for the purpose of generating remitter and making necessary filing fees without having recourse. These two suggestions, I paired them together, they're administrative, and I thought to read them out. Generating remitter and make necessary filing fees without having recourse to bank or private individuals for this service. I hope this development is introduced, like that's what obtains in the High Court now. And it will aid the course of justice delivery, both to the bar and the general public. That without necessarily having to go to the bank every time there's a need to file, to generate remitter to be able to process this. I understand that's what it is. Yes, that's currently at the High Court, that has been introduced. And also, madam, related to that is still on the administrative, which your lordship has been. Thank you, my lord, for the practice direction, which are stressing the case of litigation, the cost of litigation within the court. However, the challenge of filing union cases in Abuja and Lagos is bringing untold hardship to the people, especially in far-flung jurisdictions where union cases need to be filed. Please, can the court kindly assist to include Port Harcourt or Uyo for such and few other regimes for South-South? My lord, this has also come in, but I note that in the case disposal raised, my lord referred to yesterday.
The union cases are restricted to the ones dealing with elections. Because what we find in practice is, and I don't know whether it's deliberate or not, they wait until during vacation.
So other union cases can be filed in other jurisdictions.
Usually they wait until vacation when we have only judges in Lagos. That's when they begin to, in any event, our thinking is this: for delegates conferences, majority of the unions, in fact, over 90% of unions, their headquarters is usually in Abuja or Lagos. And the practice directions is clear as to union elections, not other union matters. We don't want situation, because we had an experience last year, forum shopping. Somebody filed a motion, a matter in Lagos to stop a delegates conference and a union's election. He secured an ex parte order for 14 days, which expired, but before the election. Instead of moving his motion on notice, he came and filed for discontinuance on the pretext that they are going to settle out of court. He then left Lagos and went to Ibadan and filed the same case, word for word, and got the vacation judge to secure and give an order ex parte without revealing that the same matter was filed in Lagos and withdrawn on the basis that they are going to settle out of court. We felt that that kind of forum shopping does not do well for us. So that's part of the reasons which influenced the decision to say, okay, to be able to streamline these matters, file only in Lagos or in Abuja. That way, if Lagos doesn't solve it, the only place you can run to is Abuja. And when you come to Abuja, you will meet us, not from Lagos to Ibadan or to somewhere else. It's to prevent that kind. In fact, if you look at the wider level, NJC had to also give instructions regarding the political parties for the same reason. People will live where the action is, where the cause of action arose, and go to another state and go and file. Is to prevent those things that necessitated this.
Thank you very much, my lord.
There's one other one.
Yes, the first question was
The
around
first one was on what?
Remitter.
Remitter, I think I gave instructions to our accounts. And I don't know whether it was in relation to First Bank only, that they should put POS at every registry where you don't need to go to the bank to be able to make payments. And I know they are doing it. What I don't know is, and I need to find out, is whether it extended to all the divisions and the registries. That's something I'll look into. But I know that that instruction was given to avoid people going to banks to be able to make such kinds of payments.
Yes, well, thank you very much. Kelly Ogbe, one of our colleagues joining online, has asked, is it not possible to have a uniform standard in judgment writing by judges of the court? There are some of the judgment you will read and you cannot determine the fact of the case until you have read the full judgment to the end.
He doesn't want to read the full judgment.
You read with some others from the first 2 pages. You can know the entire fact.
Actually, the question of judgment writing came to my mind. But because there are Supreme Court decisions that says the style of judgment writing differs according to individuals, and they are not ready to make a hard and fast rule, I didn't think it wise that we should also make a hard and fast rule about it, even in the rules. But if you observe with us here, we've tried, for instance, and I think it was a lawyer who drew my attention to it, Professor Dakas, to be very specific, SAN in Jos. He said, look, since we put our judgments on the website, it will be necessary to paragraph and number each of the paragraphs, for the simple reason that once it goes into the website, you no longer can talk of page this, page that, if you do not do it, for instance, in PDF. But it's easier to refer to the judgment when you refer to numbered paragraphs. And I think a good number of us are now doing it, numbering the judgment according to the paragraphs, just so as to make easy reference. But the other part is mentioning, it depends on the style of the judge. You can't go and tell a judge, for instance, this is the style you must take. What makes him a judge will be indirectly taken away from him.
Yes, my Lord. 2 questions taken together. Emma Warren. What are the exceptions to the rule if we are to adopt the position that limitation laws apply to divorce dispute? What happens when there are alternative dispute resolutions adopted by parties that take some time before they break down and invariably lead to the suit or even health grounds? Then Valentine Buru asks, why does the NICN ADR Center not have a working process which allows complainant to file or refer cases directly to the ADR Center as permitted by the Federal Court ADR Center and other multi-door courthouses? Does this not defeat the flexibility associated with amicable dispute resolution settlement?
Like I said during the legal year speech, these are some of the things we are looking into. Right now, the instrument regulating the ADR Center insists that until you join issues, you can't even be referred to that center, which means you must have filed a case, the other party must have responded, and all pleadings must have been entered and issues joined. Then you, but we are looking into whether we should retain that or change it. So those are some of the things we are looking into. But like I pointed out, ours is even restricted to only mediation. They don't do arbitration. We're also looking into whether certain kinds of arbitration can be done. But more importantly, we're trying to look at maybe from a monetary point of view. Somebody comes to court, everything he's asking for is not more than 1 million naira. Should you go through the whole hog, or must you arbitrate such a matter? These are some of the things we are looking into in terms of considering amending the instrument establishing the center.
Thank you, my lord. So we had someone ask a follow-on question on disciplinary hearing. And the question was around whether an employee who has been hauled before the tribunal is entitled to the records of that tribunal, particularly when the tribunal finalized their report, there were certain other individuals that were indicted. Can the employee say, I want a copy? Are they entitled to the copy of the findings of the tribunal?
Naturally, most based on rules of fair hearing, you are entitled to it. How useful it will be to you is up to you. If others were indicted and they are not brought before you, of course, the rule of law is simple. You don't build a case based on the right of somebody. You build a case based on your own right. The only exception is where you are making a case of unfair labor practice, in which event comparison becomes part of the requirement. Then you can begin to say, oh, he did this to A, he did this to B, but when it came to my turn, he did something different. And then the law will look at it and see if it's a question of unfair labor practice rule, whether it has been established or not. But strictly speaking, yes, you are entitled to. But of course, subject to rules of evidence. If, for instance, you ask for it and it is not given, your pleadings will tell you to file a notice to produce. If it is not produced, our system says the only thing you can do is to produce secondary evidence. You can't even hold it against them. But if you want to hold it against them on the basis of Section 167 of the Evidence Act, then in your evidence, you must also indicate what that evidence is. If, for instance, your argument is that I was exonerated, and you said, bring the report to show I was exonerated, and they refuse, then the court may make an adverse finding against them that they are afraid if they bring it, it will prove you were exonerated. But if you don't make that statement that you were exonerated, you merely said, bring it, without indicating the evidence upon which you want it to be brought, then you'll be with the responsibility of secondary evidence. And if you cannot bring the secondary evidence, of course, that thing will go against you.
Thank you. And so now we're going back again to the EFOSOC rights. But I stopped for a minute. I remember that Ahana had wanted to speak to the question of employers' rights. When the question was first asked, he had wanted to give us the Trinidad and Tobago position.
I thought that her lordship, I know you all say his lordship, but I thought that her lordship did justice to the topic. The question of employer-employer relationship is really a question of power and a question of control. And therefore, that is why there are rights to protect the worker, because the owner or the employer already has that control. There are rights on both sides, but always remember that these rights are circumscribed by law. So although the employer has the right to hire and to fire, those rights are circumscribed by law, meaning that there might be other pieces of legislation which will say how the hiring must be done or how the firing must be done. And similarly, with respect to the worker. So rights, these rights are not unfettered rights unless until right. one of the fundamental rights around the entire world is the right to strike. But in Trinidad and Tobago, we have a judgment from a former president that says one man's strike is another man's lockout, meaning that if the the union goes on a strike, the employer has the right then to lock out. And then we have to see who is in breach of the law. But I thought that the presentation did justice to the question.
Thank you. So going back again to the ECOSOC rights, to what extent can employees push for the advancement of ECOSOC rights under the International Covenant on Economic, Social, and Cultural Rights to be treated equally regardless of gender, right to work, and to do so under just and favorable conditions, right to form and join any trade union of one's choosing, saying that these rights are also contained in the fundamental objectives and directive principles of state policy in Chapter 2 of the Constitution, which is non-justiciable. Will the court not be seen to be enforcing non-justiciable rights by applying international conventions that somewhat establish rights contained in Chapter 2 of the Constitution?
I don't know where that question came from. If I were still the lecturer that I was, I'm not sure the person who asked that question will pass. One of the first things they teach in constitutional law is this. Despite the fact that Chapter 2 is non-negotiable, is non-justiciable, if another act or law makes provision on that issue becomes justiciable by virtue of that right. So the question itself is self-contradictory. If a right is in Chapter 2 and in Chapter 4, is it not justiciable? But I thought the more important question was those matters in Chapter 2 that cannot be found in any other law. I give a simple example. Section 14 deals with federal character. Federal character is non-justiciable, right? But there's a federal character law which establishes a federal character commission with rights and obligations. Are you saying you cannot go to court on the basis of federal character law? So the first thing we are taught is that if another law covers, take for instance, discrimination, human dignity, they are in Chapter 4. You can litigate them on the basis of Chapter 4 without reference to Chapter 2. But let's go back to those issues that are in Chapter 2 that are not in any other law. Take, for instance, the right to work. You may not find that in any other law, but you will find that in international instruments which Nigeria ratified. So today, by virtue of the power and jurisdiction of NIC to apply international best practice and conventions ratified, it means you can build a case on the right to work on the basis of an international instrument that Nigeria ratified. Sometimes I always say that we shouldn't be doing the work of lawyers. You are the ones who get paid. We don't get paid. This advice you give, a lawyer gives it and collects millions. We do it and we sometimes get insulted for it. Very soon now, somebody will say, I have jumped into the arena for saying this in public. Even the time before Skybank and EU, when the right to go on appeal was acknowledged, I said, even under the old order, which allowed appeals to go on the basis of fundamental rights, what is it in labor that you cannot build as a fundamental right issue? If you talk about human dignity, the whole concept of dignity of labor is built into it. If you talk about wages, there is right to property. Is money not property? Freedom of association, is it not a fundamental right? Freedom of expression, is it not a fundamental right? Depending on how you couch your case. I know that a lot of people felt the fundamental right issue that is being talked about is fair hearing, fair hearing. But of course, there are decisions that says, look, fair hearing in itself has its own limitations. I'll give you a simple example. You cannot go under the fundamental right enforcement procedure rules and your complaint is that you are not given fair hearing. Because if you do that, do you know the logic? It means for every decision of a court of law, you can go under fair hearing, fundamental rights enforcement procedure rules. So the courts in their best judgment said no. While you can do fundamental rights enforcement procedure rules in respect of every other right, you cannot come under those rules and your argument is simply, I have not been given fair. In other words, fair hearing is not a litigable cause of action for purposes of fundamental rights enforcement procedure rules. Sometimes we need to be more creative. There are some of these things that I see, and when I say lawyers need to go back to school, when it talks about labor jurisprudence, I mean it, because things is because we still carry the common law perspective. We don't want to see, things have been given to us on a table, on a platter of gold. We don't want to use it.
Thank you very much. Employers seem to be constantly getting the short end of the stick these days in the application of international best practices and labor standards. During the peak of COVID-19, employees refused to take the vaccine and also refused to be subjected to constant testing. Yet employers are required by law to ensure a safe working environment for employees. The ILO advocates social dialogue as a solution to this, but employees have remained unyielding and unbending. Will the termination of an employee on grounds of refusal to vaccinate or be subjected to frequent testing or contributing towards the safety of the workplace be adjudged as discriminatory? Can employers mandate vaccination in view of a liability that may arise from an unsafe workplace? What options are open to employers? Are employees going to be given a leeway to avoid responsibility for occupational safety and health?
I know that there is a case pending in the Federal High Court on this issue. So I don't think it's wise to make public comments on it. What they did was to pass laws first, mandating vaccinations for it to be held against people. I'm not too sure there's a law we pass in Nigeria. I'm not too sure. But because the matter is a live, I'm not too sure it's wise to discuss it here.
So the Nicn was unfortunately recently embroiled in controversy surrounding the issuance of orders against political holders, which led to an assault on the court in Imo State. How is the court addressing this affront?
Like I pointed out, first we shut down the court. We drew the judge because apart from demonstrations in front of the house of the judge, we also had 4 of our staff who were arrested, and then security operatives of the president judge were withdrawn. So I felt that there was need to take some drastic measures. So we closed down the court and then with the judge. A friend had actually called me and said he was with the governor who wanted me. So we spoke on phone, and I made it clear to the governor that the issues in Owerri didn't really even start with this administration. During the time of Rochas Okorocha, when he was governor, there was a time a big ditch was dug in front of the judge's house, And for 2 weeks or so, the judge could not even drive out the car to office. So our thinking was, if Owerri didn't like having an NIC in their place, we can as well shut it down. But His Excellency asked what we needed to reopen, and I told him I needed security guarantees. As I'm talking to you, that's what I'm waiting for. It has not been given, and I have not seen cause to reopen. I must admit, the local bar in Owerri and the national MBA, they've been on my neck to reconsider and reopen the court. We are looking at it. One option open to us is to ask that Owerri cases be taken in Asaba. That is one option. Of course, the other option is to reopen Owerri itself. But if we don't get the security guarantees, on what basis are we reopening Owerri as Owerri? The only thing we may do is to say, okay, go and take your cases in Asaba. So if we wait and the security guarantees don't come, we may have to ask that Owerri cases taken in Asaba.
Thank you.
When I don't know, maybe we'll take 5, 6 more questions.
So that we can get ready for the evening.
Absolutely. Okay, my lord. So we'll
Maybe
take
3 questions.
3 more questions. That'll be it. Well, the expansive one jurisdiction has been raised again. Is the NICN donated with jurisdiction to resolve tort-related complaints arising from and or in the course of work?
That's number what?
That's number 17. And whilst at that, I can just
let's explain something. Here again, we're having differences even in opinion from the Court of Appeal. The one that has been notorious is jurisdiction over defamation. Our original stance as NIC is that we don't have. There's a case that came up in Benin, Court of Appeal. A panel of the Court of Appeal in Benin, I think in 2016 or so, held that we don't have jurisdiction over defamation. In the same case, another panel in 2018 held that we have. When I say the same case, I mean the same case in terms of suit number and parties, held that there is. Unfortunately, in 2021, there's another Court of Appeal decision that says we don't have in defamation. Like I said, as a court, our stance is we don't have. And our reason is simple. I always like to ask this question. If a worker stabs another worker in the workplace, will you file for murder in National Industrial Court? The answer is unlikely going to be yes. Now, each of these torts is sui generis. In other words, they can found an action in their own right. And the problem with defamation is this. All the cases that have come to us in defamation are cases where they were tied to termination. And because it was simply made as one of the claims. Now, you know that defamation, because it can found an action in its own right, has its own requirements. And because it has its own requirements, if you don't plead and prove those requirements, you cannot succeed. And in all, if not in most, if not all of the cases that have come before, none of these requirements was even proved. I know I did one where a claim in defamation was made based on this 2018 decision that says we have jurisdiction over defamation. I assume jurisdiction, but nothing in terms of the elements was proved. And I was left with no other option but to dismiss it. Now, this is the effect. Once you dismiss, you no longer can litigate it. You can only go on appeal. So, as a matter of choice, we think we were doing the parties good to say, look, we don't even have jurisdiction, so that they can go and file elsewhere where they think they have jurisdiction. But unfortunately, they keep coming to us. Maybe because they think we don't know anything about defamation, so they can easily get a verdict. We are not supposed to be judges knowledgeable in defamation. We are supposed to be only judges knowledgeable in labor law. So maybe because of that, they like to come to us. But unfortunately, that has not worked. But there are other areas in tort. Take, for instance, workplace injury. We take jurisdiction over that because the third alteration specifically or the act that replaces any of them. Secondly, we also take jurisdiction in relation to the thought of interference with third-party rights or contracts. Why we take jurisdiction over that is that historically that thought rose out of trade unions at the point when trade unions got rights and privileges protected by law. Each time a strike was made, it automatically meant that the company or the organization against which the strike was made was stopped from meeting its third-party obligations in terms of contracts it has entered into. And the common law decided to generate this tort. So for that historical reason, when complaints for interference in third-party rights or the thought of interference with contracts comes up, we take jurisdiction over that. But other than that, when it comes to other thoughts like dirty, new conversion, false imprisonment, assault, battery, we generally believe that you should go to the regular courts and deal with them. When I was in Lagos, I was able to develop this principle. It's not a hard and fast rule, but it helps. And I always tell myself when faced with borderline cases, which law will I use to solve this case? If it is employment law, I will take jurisdiction. That is why when you complain about staff loans, we take jurisdiction if that loan is an aspect of the conditions of service. We will take jurisdiction because we are going to deal with it as an employment rights issue. If the law that I will use case is not an employment law, we will not jurisdiction. That is why, for instance, we don't take jurisdiction over employment tax, because the law you need to resolve is tax law, not employment law. So we make some of these distinctions, but like I said, the Court of Appeal decisions in this area are also oscillating. We have some saying we have jurisdiction, we have some saying we don't have jurisdiction.
Thank you, Madam. 126.
My Lord, yes, my Lord, I will. Go ahead.
Is it a settled principle that every employer must give reason for any form of termination of an employment? That's number 22.
Nigeria is a little different. We didn't ratify Convention 158. So strictly speaking, Convention 158 will not apply as a matter of course. But Convention 158 is evidence of good practice. Evidence of international best practice. So for you to found an action on the basis of Convention 158, the requirement for us in Nigeria is that you must plead, prove it, and then hope the court agrees with you. But I know over time, starting with the banking sector, we started having a rethink in terms of whether you can wake up, terminate the services of a banker without telling him why, knowing fully well there is a requirement that says you must report to CBN. And once he's reported to CBN, he will never get another job in the financial sector. For us, that reality means that it shouldn't just be that you are allowed to terminate without a reason. And of course, we have built in overtime. So you are going to find some decisions of this court where Convention 158 has been applied. Of course, we are yet to get a Court of Appeal decision to say we are wrong for doing that. Other cases will come up on the basis of the cases that applied Convention 158 being cases of judicial notice. I don't know whether you get my point. Subsequent cases that are going to come up will be cases that will be on the basis that, oh, my brother judge did this, I can take judicial notice of it. So yes, there's a gradual, I'm not going to say we've arrived there, but there's a gradual transition to acknowledging that you cannot just terminate without cause.
So much, my Lord. We just take the last two questions together. How does an employer draw a line between a crime and a misconduct in the course of internal investigation to avoid playing the role of the courts and wrongfully involving the police? Any useful hints, my lords? There are court decisions to the effect that when an employer is lax in this disciplining worker, the employer is deemed to have condoned the act and can no longer discipline the worker for the act. Is this an absolute rule, or are there permissible exceptions for recourse to record of the worker's misconduct or poor performance? And the other question is, in one case, an employment contract was confirmed for 11 months. Was not confirmed for 11 months. Court held that it was contrary to the terms of employment. They refused to order confirmation. In another case, an employment was not confirmed for 8 months and 2 cases. The NICN held that the contract employment remained probationary and that no notice of termination was required. Whereas yet in another case, I mean, this is about conflicting positions. Now, the court held that the probationary contract of employment can be deemed to have been impliedly confirmed if it continues without confirmation. The second one, then the first one would. Okay, yes, my justice, that's it for now. Confirmation.
Yeah, may I stand on the existing protocol? Question 21. I want to first of all start by saying that just like any other contract, a contract of employment is supposed to have terms. Now, where there are no terms of contract of employment, it is in fact a breach of Section 7 of the Labor Act, because the Labor Act is very clear that within 3 months of commencement of employment, there must be terms of employment given to the employee. That is why every contract of employment has one very important term inserted in it, and that term is to state the period of probation. Now, the reason for this is this. Probation determines whether the employee can continue in the employment after that period, because within the periods of probation, the employer has every right to terminate without notice. But in practice, we've seen that most employers hold the employee to ransom. Even when the time for confirmation has come, they refuse to confirm. And they hold the employee down for 2-3 years, then suddenly they terminate the employment And the argument will be that the employment was not confirmed. And for that reason, the employee cannot take whatsoever benefit that accrues to a confirmed employment. You see, that practice, to my mind, is an unfair labor practice. When a stipulation or a term of employment is very clear, the intendment is that there should be compliance with that term. It should be enforced. The term may be enforceable either by the employer or by the employee, depending on whose the term is targeting. Now, in our jurisprudence, we've come to the conclusion that at the time of confirmation, the employer is supposed to do two things. One, either he confirms or he queries the staff for non-performance and extends the period of confirmation. Where he fails to do that, then the worker after that period is deemed to have been confirmed. If you look at the question is talking about, the first arm of the question is talking about that unemployment was not confirmed for 11 months.
Yes.
But the court held that it was contrary to terms of employment, but refused to confirm the employment. Well, those kind of situations, you must first of all ask yourself, what kind of employment was it? Was it a master-servant's relationship, or was it a contract with statutory flavor? If it was a master-servant's relationship, even though the court would have found that the non-confirmation was in breach of the terms of the government body, the court would not be able to order confirmation and reinstatement because it's a private contract. But where such arrangement is in respect of a contract with statutory flavor, the implication is that that contract is deemed confirmed after the period of the probation. Now, I had an opportunity to deal with this kind of situation in the case of Chinoye Amanze and Union Bank. One of the issues for determination there was whether the non-confirmation of the claimant's appointment violates the contract of employment. The employment was supposed to be confirmed within 6 months. The employee was given what we call a target to bring in close to about, I think, about 15 billion naira within the period of 1 year during the period of confirmation. And after about 2 years, Union Bank terminated the employee on the grounds that he couldn't meet up with the target that was given to the young lady. And the lady brought reviews of her performance. And one of the review clearly stated that they is asset to the bank. The other review came, and the review was 76 of that review for the second year. So I started questioning on what basis would that appointment not be confirmed. And the bank produced a piece of paper where she only signed that she was going to bring the so-called target. He was going to bring customers that can bring that kind of money into them. And I looked at it. Under the common law, it is very clear. It is the duty of the employer to provide work, and not the duty of the employee to bring business to sustain the business of the employer. For that alone, then the argument couldn't hold. So when I reviewed the case, I realized that this was a clear case that she ought to have been confirmed. You find out that most employers hold confirmation as a weapon against the employees to toss them around to do whatsoever they want to do with respect to their employment. So when you find a situation like that, the jurisprudence in Nigeria is that if the period of confirmation comes, you must confirm. If you don't confirm, query the staff, extend the confirmation. But if you fail to confirm, that employment will be deemed confirmed. And in the event of your terminating that staff, you will get all the benefits of a confirmed staff. Thank you very much.
Thank you very much.
Thank you.
And the final question, to my Lord Honorable Justice Uguaya, the one on drawing a balance between crime and misconduct. The mic. My Lord Honorable Justice Essay. Yes, before in the judgment my Lord just referred to, my Lord said my Lord was able to find that under the common law, it is the duty of the employer to provide work for the employee. Yes, we're still looking at the employer's rights to balance it. Since the court can also apply equity, so if to extend beyond common law, under equity, it shouldn't be a balance that there might be times when the employee must sustain the business. But also on a lighter note. Yes, man. Yes. Accordingly, like I said, that was really.
Yes, if you fail to remunerate the employee for that extra effort, yes, then that stipulation is also null and void. Secondly, the so-called documents containing the target was not a contract because it was only signed by the employee, which was like a good first way of saying, this is my best effort, I will put in my best effort. If it was a stipulation that the employee ought to have taken very serious and hammer, and then you would have been a part of the contract of employment of the claimant in that matter.
Thank you very much, sir.
Okay, thank you very much. This question is very tricky, but we have to look at it systematically as it appears. First of all, we have to note that every crime is a misconduct. I hope I'm there.
Yes, my Lord.
Every crime is a misconduct, but not every misconduct is a crime. So when we start with this logical background of delimiting the line, the dichotomy between mere misconduct and misconduct amounting to crime, that's the starting point. So crime is already known clearly in the law books about what constitutes crime generally. But what constitutes misconduct is a matter for the employer in drawing up in the condition of service. Now, to get that right, it means that one of the hints I'll give is that employer can now clarify in the condition of employment or condition of service what constitutes misconduct in its workplace. If not, they will run through this problem of not knowing the borderline between crime and misconduct, because it's not every misconduct that amounts to crime, but not every crime. So in that logic, what the employer is targeting is not crime. That's another hint. Are you targeting to start becoming investigator of crimes against your employee? So if your target is on misconduct, that means you have the burden to define what you want to classify as misconduct in your place, which also automatically includes crimes. So crimes are already there, but other ones that do not amount to crime, it is your duty to point them out as so and so behavior amounts to misconduct in so and so office. So like Lord the President said yesterday concerning tattoo and all these other things. If, for instance, and in the condition of employment, it is clear that certain type of dressing, including designs of the body, like tattoo, is a misconduct in this office. As you are coming in, you know that it is not part of what is tolerated in it, particularly industry-wise. I don't know of a judge in Nigeria now that's bearing tattoo. Are you getting it? No, yeah, it's not. I'm sure if you come to an interview with it, such tattoo on your face or anything, NJC panel might be looking at you somehow without any written rule about discrimination or whatever. But it is an industry-based conduct. Are you getting it? So certain type of industry will tolerate certain things or include certain things as their misconduct by virtue of being in that sector of the economy. That's another part of it. Now going forward, on misconduct, this issue of condoners. To condone a disciplinary offense or a disciplinary issue is a prerogative, is a right of an employer. That means an employer can decide to close eyes over a misconduct. And once done, it is taken as done. It cannot be revived. It cannot be revived because it will amount to unfair labor practice, where you have closed a chapter on an issue and later on you came up to revive it in a different form. It's not allowed because you have a right to condone and also have a right also to discipline. And if you are now to discipline that person, that means you must originate it with a query. That's the only way you can revive a condoner, because that query has been issued and then the outcome of the query must be determined. And that is where many employers are having problem condoning and not, again, disciplining or invoking the process of disciplinary, which starts with a query. Once that starts, it's expected that it should be concluded and you now know the outcome. If you say that you are doing investigation, investigation should also not be a tool for involving police and criminalizing an act. I will list some cases where some of these issues have been discussed in my court. When you see that type of scenario where a complaint is made to the police, instead of the employer going into internal way of investigating, the police is at large. The police may not even get the details, but your intention is just to keep the staff out by taking them to police to investigate. Whereas you would have done your in-house investigation, and that your investigation internally would have constituted even something you give the police, assuming you want to take a criminal wing out of it. Otherwise, an employer is not bound to take a criminal action against an erring employee. An erring employee that have misconducted himself should be punished on the basis of misconduct only. And if that happens, the person can as well leave the office on that basis. Finally, when you see the aspect of malicious prosecution, it can arise against an employer who failed to do a thorough investigation and took an employee into criminal prosecution, after which the court now discharged the employee. If that happens, the employee will have a right to sue for malicious prosecution because he has been taken through criminal processes again without proof. To that extent, the person can come back and sue the employer or ex-employer, as the case may be, on that ground. So many of these situations is about doing thorough investigation. An employer has the right to do thorough investigation and has to invoke the right of suspension or interdiction. This is the right they have in order to enable them to do a thorough in-house investigation. So you should not use suspension as a punishment itself. Suspension was intended to enable you carry out investigation into allegations. But once you use suspension as a punishment, you run a risk of bearing liability for unpaid salaries or payments within those periods of investigation. So also is interdiction, which are usually used in public service. I have done some cases which you can look at, even some online. Yemi Edokpai against ABN Limited, suit number NICN/PHC/146, 2020, delivered on January 31st this year. Rabiu Olakunle against Lagos Airport Hotel Limited, suit number LA2429, 2015, delivered on June 2015, 2020. And Dr. Debe Scholastica and Lasso. This is a very popular one involving a lecturer who altered results, and it was one of the judgments that made news about a lecturer who altered results submitted by colleagues and only has a problem with one allegation, only for it to discover that about 1,900 and were involved. So such cases are there, but there's one case which I mentioned here, which is very important for us to know the impact of that judgment. Concerning lawyers finding their cases on Section 36 of the Constitution. We have several of it, but it's failing on daily basis. It's failing on daily basis. That's mine was almost the last one because I have to refer to my Lord President's own case. When I did it in Mrs. Olabisi Taiwo against Governing Council of Estates Valuers, judgment which I delivered in 2021. Look at paragraph 39. Let me just read out that part to say what my Lord President said in that judgment. That the case is Dr. Selina Arinye against University of Lagos. His Lordship extensively reviewed the current legal regime of the rule of fair hearing as applicable to workplace as follows. In his own words, I don't know whether I'm wasting time on that. Okay, but yes. So, but the important thing is that lawyers should know that Section 36 is no longer a ground. You find it in common law, natural justice, rather than saying I was not given fair hearing by the panel under Section 36. Thank you very much.
My Lord, we thank your Lordship. Indeed, that is the beauty of these interactions. I mean, sessions like this, and we're taking it on board, no doubt. Only to add that when my Lord was coming on the microphone, somebody actually sent in this. I think the person knew that my Lord's intervention will be heavily loaded. And I read, it says, a number of the online attendees have asked for the written interventions made by my lords and the cases cited. Would it be possible to get this and circulate? So today, some interventions have been read out. And I'm sure they are not trying to use those interventions against the court. We also want to take them to lead. So at least at the level of the employment and industrial relations of the SBL, my lords we are hoping that my lords would avail us those so that we can share with those online. We have over 150 people online, and it's a recurring question. Over 200 people online, and it's a recurring question that they would like to have some of the written interventions for us, lords, I mean, this is the only time we ever get to do this, for keeping my lords there for over 4 hours. In fact, the questions are still there, but it shows that we really want to engage the courts to really know how to plead our causes when we come to court, and so also to share our areas of concern, some of which I think today we've been able to share. And to every good thing, there must be an end. And I think it's at this junction that we'll be drawing curtains and still going on with the sequence of the program. But if my Lord will permit me, this is not listed, but there's a group here, the Employment and Labor Law Association of Nigeria, ELAN. ELAN is a premier association of employment and labor lawyers in Nigeria. It's an active group. Mission is to become the preferred resource point for stakeholders seeking high-level expertise on employment and labor-related matters. The trustee, I mean, 1 or 2 persons from the association, they are here to make a presentation to the courts. I think books. So we disclose ahead. And they've asked that we should perhaps give this small opportunity to quickly do that. So as I call on Mr. Jamiu Akolade, trustee of ELAN, and and Nathaniel Odiaka. And then, who interestingly, both are also active members of the section on business law, employment, and industrial relations. And we'll be doing the vote of thanks after the closing remarks by my Lord Honorable Justice Esori. So we hand over to you. Do the presentation, please.
Okay. Good afternoon, everyone. Permit us to stand on the existing protocol that have been stood on since morning. Before we give the vote of thanks, we'd like to okay, yeah, that's what I'm saying. So before the vote of thanks, we'd like to, on behalf of Ellen, thank the court for the kind invitation that was extended to the association to be part of this year's new legal year activities. And we have a number of members from the association who have attended this program since yesterday, sorry. And on behalf of the association, made up of practicing lawyers, academics, in-house legal counsel, and generally people with interest in labor and employment law issues. We've had a number of members donate books to the court's library, and we thought this would be a good avenue for us to present those books. So this package, of course, the Learned Silks firm by association is also a member. So maybe I'll prefer present the book from the firm of Birchstone and Grace. This is a book on the Employment Law Review, the 13th edition, from the firm of Birchstone and Grace. As the court has also encouraged lawyers to look into new areas of the law, we have 3 books here. The first is from Olumide Babalola, who is also a member, on privacy and data protection law in Nigeria. Also is a case book on data protection, Olumide Babalola too. And then a much older book from him, case book on labor and employment law. I think that was written sometime in 2013. And then my own modest contribution to the field too, the employment law handbook. We have 5 copies of that. And we are donating all of these books to the library as a contribution to the court and the emerging jurisprudence of labor and employment law in Nigeria. We thank the court very much for all this collaboration so far. Well, okay.
Thank you very much, Ellen. Thank you for that. The executive of the EIRC will take a picture with the judges right now, before we take the vote of time, before we take the closing remarks from Honorable Justice Esori. So picture between my lords and the executive, the executives of the EIRC.
You can stay here.
No, the tall ones can stay this way. So, my lord.
My Lord, the President of the National Industrial Court of Nigeria, and our esteemed guest, the President of the Industrial Court, Trinidad and Tobago, Her Honor, Mrs. Deborah Thomas Felix. Please permit me to adopt the already existing established protocols. We have all watched and listened with keen interest in this bar bench forum, and most of us have even participated effectively. Naturally, we are all happy that this forum has been put in place by both the MBA and the president of this court. The forum, no doubt, will help to clear some gray areas of the labor law and practices. It has already started clearing the gray areas, and thus enable the MBA and the National Industrial Court judges to work better together in future. And the challenges that we may likely meet in future will therefore become simpler. And at the end, we shall achieve sound and speedy justice delivery, which is the target of this court. We thank the MBA members here present and those participating virtually. We are glad that the interaction will henceforth be an agenda on our legal year celebrations, as promised by our president. Now, may I remind all of us that the second part of this day is a dinner at the Sheraton Hotel and Suites by 7 p.m. today. And it will take place at the Ladi Kwali Hall of that hotel. We hope you shall make our time to come there and eat and relax with both friends and colleagues. Thank you very much.
Thank you very much. I now invite Jamiu Akolade and Natalia for the vote of thanks.
Probably we'll need one. Good afternoon again. And so it's been a beautiful end to 3 days of an enriching and robust discourse on an area of law that we all love. And in appreciation to all the stakeholders that have made this 2022 legal year a resounding success, we'd like to say thank you. From our Honorable Justice B.B. Kanye, the consultant of last resort, according to my Lord, Honorable Justice Dele Peters, we thank you very much, sir, for your continued willingness to interact with the bar. Someone was mentioning while I was on my seat that is not aware of any court that does this. And I think that is a fact. We thank you for your leadership and we thank you for your collaboration with the bar. I honor Deborah Thomas Felix, President of the National Industrial Court of Trinidad and Tobago. We also thank you for coming all this way to show fraternity with the Nigerian Employment and Industrial Relations law practice. And we're thankful for your enriching views on the contemporary comparative analysis with what the situation is in Trinidad and Tobago.
Thank you very much. And so also to the Honorable Justices of the National Industrial Court, we want to say thank you for gracing this occasion with your presence and sharing your wealth of experience with us. We also thank the learned six who also are here. And I also want to thank the chairman of NBA SBL, Dr. Adeoye. Thankfully, they really stopped you in giving your speech. We're very grateful. Thank you very much, Jamiu.
Yes, and then my chairman, my indefatigable chairman, the chairman of the SBL Employment and Industrial Relations Committee, Mr. Ose Okweku. This is a success for you personally and for the committee. We're all part of the planning process. We know all it took to put this together. We say congratulations to you. And we thank you also for your leadership in this regard. And for all the members of the NBSBL larger body on Employment and Industrial Relations Committee, many of whom are here, we are also part of them, actually. We thank you for your efforts in putting this together, and we hope that next year's event will also be much larger and better than this.
Thank you. So when you have an event like this, and to have it in a very successful way, you have the combination of two wonderful anchors, Mary and our Mr. Folabi Kuti, SAN. Anytime you have the two of them together, you are assured of the very best. Thank you very much for what you did today. We're very grateful. And to our online participants, thank you for your patience. A lot of you logged in on time, waited for 1 hour before we started, and you remained patient. We want to say thank you for your patience and thank you for also making the program very interesting by all the questions you asked. Thank you, Jamiu.
Yes, special thanks to them, because last time I checked, we had about 182 people online, far more, maybe more than double the number we have here. And so there's a piece of announcement we should make regarding this program. So this has been a recorded event. And for those who are interested, you'll find the recording available on YouTube and other social media channels. You can simply search for National Industrial Court to get those social media handles and platforms, and you'll be able to watch this recording. Or you could also visit the NIC's website for these live recordings. And the website is, the website address is nicn.adr.gov.ng/. With that, will invite Justice Oba closing remarks before. Okay. She's done that already. Okay, thank you very much. So I guess we don't have the privilege of calling it a day, and we wish you a good evening and see you at the Sheraton. Thank you.